Yeah.
Yeah.
Okay. You want to arrange that to where you can see it the best.
Oh, is that the same thing?
Yeah, this is the Zoom.
That like freaked me out when I went on stand and I was like,
Ah. I'm turning this way. Why does this?
just flip the stand. Like, no, it is.
But this, y'all are the timekeepers, and that's the jurors. So this is not. Maybe it'll like this table better. Just it knows y'all's job's too hard. It's good. Why was that so difficult? You just went to the attorney, but it's okay.
Oh, yeah. It's probably the best.
Okay.
Got it. Are the judge pairings out?
Oh.
Yeah. I got mine. I'll get those.
Rest judges present. And then when they're ready to start, press ready to start.
Awesome. Yeah. Should be all set now.
You're riding.
What? This easel is broken.
What?
Easel is broken. It's not intense. You've already seen it. Right. And this is a lot of. Is there another easel we can speak?
Wait, what's wrong with him? Oh, I see. Weird. Okay, I can go to another. I mean, I'm seeing nothing. I'm gonna hope, don't close it. There's no like nut or thing on the other side securing us. Okay, but yeah, it'll hold for this, just don't like move it. Like that. Yeah. Okay, that's good. Thank you. I'm gonna see that and I'll this one. Hi.
Like, oh, and take it from the back. Yeah, yeah, absolutely.
I'm finishing the slideshow.
You're gonna sit there. Very good. Move this away from directly in front. No, I got it directly in front of you guys.
Sounds good. I think it's like the tournaments. They just keep it there like if they need a witness term. We don't have to, okay.
We haven't seen it before. I think that this is our. We did yesterday and today, so.
Yes.
Journal anybody ready?
Just a minute. Okay.
Welcome, everyone. This will seem a little awkward, but you can see it for just a second. Juror number 1 is opening up our door. There wasn't an easel there. I just moved the layers to whoever's. Because I think it's always good to have a beginning, a clear beginning. And although it's incredibly awkward, I'm going to do all rise. Thank you. You may be seated. The court will come to order. Call the case of Justice Carbo versus Shooting Star Gun Club, LLC, case number 23 CV 002023. Court will first hear argument and decide plaintiff's pending motion in limine regarding the claim under the Responsible Firearm Sales Practices Act. Will counsel for Justice Carbo, who is going to argue this motion, please stand and state your appearance.
Good afternoon, Your Honor. My name is Brianna Tota, and I will be arguing for the plaintiff.
And counsel, could you just spell your last name for me, please?
That's Tota, Your Honor.
Very good. Thank you very much. Will counsel for Shooting Star Gun Club, who is going to argue this motion, please stand and state your appearance.
Yes, Your Honor. My name is Dylan Shopko, SZATKO.
Thank you very much. The court will briefly remind the parties of the procedure for argument. Parties will each have a total of 8 minutes to present argument with the possibility of an additional 2 minutes in courtesy time as the court may permit at its discretion. Counsel will each have 45 seconds to present your argument without interruption, after which the court may ask questions. Counsel for Carbo will argue first as the moving party. The jury is constructively absent for this argument, so counsel should address the court. Timekeeper for plaintiff Carbo, are you present and ready to proceed?
Yes, Your Honor.
Thank you. Timekeeper for Shooting Star, are you present and ready to proceed?
Yes, Your Honor.
Thank you very much. When the first 45 seconds expires, and are both timekeepers using cards to display? Very good. Just so I know what you're doing. When the first 45 seconds expires after each side's argument, both of you please stand quietly and prominently display your time cards. Do not call time aloud unless I do not see an acknowledgement. When time expires for the main argument, please stand and say out loud, stop. Do you understand and agree to abide by these rules?
Yes, Your Honor.
Thank you. I may permit courtesy time for each side up to 2 minutes per argument. Immediately upon the expiration of any courtesy time, you're required to stand and call out time. Do you understand and agree to this rule?
Yes, Your Honor.
Thank you. Counsel for Carbo, you may reserve up to 3 minutes for rebuttal argument. How much time, if any, will you reserve?
Your Honor, I will be reserving 2 minutes of time for my rebuttal.
2 minutes, thank you. Counsel, you've reserved 2 minutes for rebuttal. Timekeepers, please stand and notify the court after 6 minutes, leaving 2 minutes for counsel's rebuttal. Counsel for plaintiff Carbo, you may proceed when you are ready.
Yes, Your Honor.
Excuse me for just 1 second.
Please pardon me. Okay, thanks. No worries, we just got an audio issue. Counsel, whenever you're ready, you may proceed.
Good afternoon, Your Honor, and may it please the court. My name is Brianna Tota, and I represent the plaintiff, Justice Carbo, in today's case. On May 28th, Justice Carbo entered Shooting Star Gun Club to purchase her first gun. However, she left with the gunshot wound after she was shot while taking a firearms safety course instructed by Drew Cantrell. Your Honor, firearms are dangerous weapons capable of causing immense harm. The Responsible Firearms Sales Practices Act, or the Act, serves to assess individuals who are purchasing firearms to ensure that they would be suitable owners for those firearms. And Your Honor, it is the plaintiff's motion in limine today to move forward with our second cause of action, to charge Shooting Star Gun Club for the reckless entrustment of the firearm to Drew Cantrell.
Counsel, doesn't the statute in this case make the decision as to whether to allow someone to purchase a gun incredibly subjective?
That's a great question, Your Honor. In order to assess the subjectivity, we must look to historical analogs that demonstrate how the act is constitutional. Bruin emphasized that an analog must be relevantly similar, but not a historical twin. Your Honor, there are many similar characteristics of the ones in the act that are similar to shall issue licensing regimes. These regimes require that individuals undergo fingerprinting, a background check, a mental health records check, as well as training in firearms handling and in knowledge of laws regarding the use of force.
But doesn't this statute go much further, particularly in subsections A and F E, to permit someone to make a subjective judgment as to character or maturity? And isn't that exactly what Bruin tells us we can't do?
Your Honor, there are many factors listed within the Act, but it's important that those factors be listed to give retailers an entire a list of factors in order to assess these individuals. And I believe what you're referencing is the law that Bruin struck down, the may issue licensing regimes. Now, those may issue licensing regimes were struck down not entirely due to their subjectivity, but rather because they required that individuals show an atypical need for self-defense. And Your Honor, they put the onus on the individual to prove their Second Amendment right should be granted.
But in this case, wouldn't shooting stars risk liability and serious punishment under this law if it doesn't make some general subjective judgment as to whether a person is mature enough to handle a gun?
Well, Your Honor, maturity is not the only factor that must be assessed when retailers apply the statute. And specifically in this case, Shooting Star Gun Club would only be held to the punitive damages if they failed to make a proper assessment of Drew Cantrell. And we intend to show you that Drew Cantrell was unfit because they displayed multiple incidents in which they handled a firearm unsafely. And so, Your Honor, with this, we ask that you look towards Heller, where it analyzed the operative clause of the Second Amendment could not be viewed separately from the purpose for which it was granted.
I've read your brief, counsel, and the opposing side, and I'm wondering what historical analog antecedent would you point to among the many that appear in the briefs that demonstrate that the framers of the Second Amendment would recognize this kind of statute as being constitutional, and not an improper infringement on the right to keep and bear arms?
That's a great question, Your Honor. I would direct your attention towards the shall issue licensing regimes that are currently widely adopted throughout the states. These regimes put the onus on a discretionary official to determine if an individual is able to use a firearm. This onus is similar to the one placed in the Act. The Act places the onus on the firearms retailer in order to make that same determination.
And I think those are compelling, but with regard to the statutes and cases which will inform the judgments of the framers of the Second Amendment, are there particular ones that you feel are most compelling to demonstrate that this kind of limitation would have been appropriate in their view?
Your Honor, again, I would direct your attention to these shall issue licensing regimes because, as I previously stated, there are many overlapping criteria between these shall issue regimes as well as the Act. And furthermore, Your Honor, the Act states that a firearms retailer must assess an individual based on the information they have reasonably available at the time. If there are criteria within the Act that they cannot reasonably assess, then it is not their burden to assess those criteria. It is simply their burden to assess what they can, given the information they have available to them. Now, Your Honor, I'd like to describe how limitations to the Second Amendment are constitutional. Heller versus the District of Columbia held that conditions and qualifications to the commercial sale of guns are constitutional under the Second Amendment. And furthermore, Your Honor, it is the country's historical tradition that amendments granted by the Constitution are not granted on an unlimited basis. In fact, the First Amendment itself has historically excluded libel, obscenities, and the disclosure of state secrets. Your Honor, the Second Amendment is a right just like the First, and it is a right that is subject to reasonable limitations. So for these reasons, Your Honor, we ask that you grant the plaintiff's motion in limine for our second cause of action. Thank you.
Thank you. Counsel for Shooting Star, proceed when you are ready.
May it please the court, Your Honor, opposing counsel, Shooting Star asks that you deny the plaintiff's motion under section 20 of the Imperial Civil Code 2007, which forbids the sale of firearms to a person whom the seller knows or should know from the totality of the circumstances to be unfit to safely use or own that firearm. Now, the burden of proof lies on the plaintiff in today's case, as the Supreme Court held in Bruin. They must prove, using historical analogies, using historical laws, and they must prove that those historical laws are analogous to the act today. However, the Supreme Court in Bruin also made clear that even if those historical regulations on firearms targeted the same issue as the act today, but in a different manner than the act today, those past regulations do not support the act's constitutionality.
Counsel, opposing counsel has made the argument that this is basically the appearance statute, basically the collision statute. And according to Justice Kavanaugh's concurrence, that's really all we need to determine to find that it's constitutional. How do you react to that argument?
Your Honor, this act is clearly a May issue law. The Supreme Court in Bruin held that those 6 states that used May issue laws, and specifically defined those May issue laws as laws that give the licensing officers personal judgment or discretion in issuing licenses. And that is exactly what the act today does. It gives the individual seller discretion on whether or not, a subjective discretion might I add, on whether or not to sell a firearm to a specific customer. And furthermore, the 6 states that use May issue laws place that burden on a government official. But the act today doesn't even manage to do that. It places the burden on a private citizen, a private business, and it tasks them, and it places them possible tasks of assessing each individual customer on that business.
Well, the counsel argues it's not impossible. The legislature has listed a series of characteristics and suggested this case would be illustrative of the way in which a gun seller could make a reasoned judgment as to whether somebody has maturity or character such as to be able to keep and bear a weapon. How do you respond to that?
Of course, Your Honor, the law gives a very long list of possible factors that can make somebody unfit. However, the law never specifies which factors can still pass the test and which can't. It doesn't.
Is that what is necessary in order for it to be constitutional?
Yes, in order for this act to be constitutional, it must use objective criteria, just like the shall issue laws that the Supreme Court examined in Bruin. But the act today doesn't do that.
Let me ask you about that. The Connecticut, Rhode Island, and Delaware statutes Justice Kavanaugh referenced in his concurrence appear to be relatively general. Would you agree? They seem to suggest that they would qualify a shall issue statute. How is this any different than those statutes?
Well, again, this law places the burden on a private citizen, not even a government employee, not a trained licensing officer. So even if it were analogous to those may issue or shall issue laws, it still, quite frankly, isn't. Because the burden, again, isn't on a licensing officer. The law doesn't even train private businesses on how to employ the law.
Would that save the statute? The state of Imperial created a training program to determine, to provide people who made these decisions some background before they sent them off to sell guns?
Sure, that might make it more constitutional, but on top of that, the law still must be re-examined and made more objective. Because the problem is then we have cases like today, where the plaintiff, Justice Carbo, is suing Shooting Star Gun Club because they claim that Shooting Star made the wrong choice.
Let me pose to you the same inquiry I gave to opposing counsel. I've read the briefs. Are there particular statutes or decisions that the founders would have been aware of to have illuminated their understanding or our understanding of their understanding of what would have been an appropriate limitation on the right to bear arms? And if so, could you identify those for me?
Yes, Your Honor. So the Tennessee laws, which the plaintiff mentions in their brief, simply punish those who went out into the public armed, wanting to cause terror. But again, it never punished those who sold them the firearms. The framers only sought to impose, or the framers only understood the Second Amendment to be applied to law-abiding citizens, meaning that so long as somebody did not have a long criminal history, they were not known to be violent, and they did not intentionally misuse those firearms in an attempt to cause violence or terror, then their Second Amendment right would be supported. Now, furthermore, in the plaintiff's brief, they mention the Northampton statutes. However, the Supreme Court itself in Bruin found the Northampton common law in England to be too ancient to represent the intentions of the founders when they wrote the U.S. Constitution. And the surety statutes that opposing counsel claims are analogous to the law today only apply to those who were firstly accused and secondly found to be reasonably at risk of carrying firearms to cause terror or offense in the public.
But isn't that what this statute does? It asks the gun seller, or importantly, to make a judgment as to whether this person is the kind of person based on age, maturity, terrorist leanings, to be carrying a gun in a society that is committed to safety for that society. So isn't this exactly the same thing?
No, Your Honor, because this is an applied challenge in today's case. Meaning we're not examining the law as a whole. We're examining how it's applied in today's case. And the way that the opposing counsel is applying it is saying that Shooting Star should not have entrusted Justice Carbo or Drew Cantrell with a firearm based on their lack of knowledge, skill, or training. But there's
And isn't that exactly what, for goodness sake, statute of Northampton, Tennessee, everything else does, which is we don't want someone who arguably is as badly qualified as Cantrell to have a gun, have a gun. Isn't the same thing? We don't want him terrorizing a community.
Well, no, because all those laws refer to people that have a long history of specific violence or people that intentionally use firearms for the purpose of violence or causing offense. But nobody in today's case is claiming that either Justice Carbo or Drew Cantrell intentionally used the firearm for violence. Meaning none of those past historical laws are analogous to the one today as it's being applied today. And furthermore, again, even the South Carolina law protected the right to bear arms to all individuals other than those known to be violent. But again, Carbo has no history of violence, therefore that law does not support the act as it's being used today. Thus, the act cannot place such a heavy burden on a private citizen with no training, funding, and very, very vague and subjective guidelines, and then blame and penalize that private citizen for making the wrong choice.
I'm ready to hear rebuttal argument. Carbo reserved 2 minutes. 2 minutes for rebuttal. There's been no use of courtesy times. The counsel for the plaintiff will have 2 minutes for rebuttal.
Yes, Your Honor. Your Honor, I'd like to begin by discussing how something can be deemed historical and we must look to how and why shall issue licensing regimes burden an individual's right to self-defense in order to see how they are historically analogous to the act that is proposed. Both of these documents require that an individual, in the case of the shall issue licensing regimes, a discretionary official, and in the case of the act, the retailer, they require that they make a determination about the the customer's fitness to use a firearm.
So counsel, opposing counsel argued that nowhere is founders' contemplation of what the Second Amendment would there be an inquiry into whether an otherwise law-abiding citizen should be able to sell or be entrusted with a weapon. Whether it's Northampton, whether it's the colonial statutes, nowhere do we find that. And this is exactly what that is, and therefore it has to be found unconstitutional. How do you respond?
To that, Your Honor, I would say that the Northampton statutes are in fact important in our analysis of this case because They are important to the as-applied challenge. Opposing counsel came up and argued that all of the statutes that were mentioned in the case law were not applicable to this case because we're looking at the entrustment of a firearm to Drew Cantrell. But Your Honor, we intend to show you that Drew Cantrell had a history of unsafely using a firearm. And that history of unsafely using a firearm meets what the opposing counsel came up and argued as the only reason that these statutes don't apply in this case. So, Your Honor, we ask that you look towards the Heller's description of the Second Amendment and find that Drew Cantrell on May 28th was not using her right to self-defense, but rather was against the Second Amendment.
Thank you very much. The court appreciates your hard work and briefing and arguing this issue in 3 minutes or less. I will issue the court's ruling during that time. Please remain in the room. Remember, you may speak only with students on your team who are participating in this particular trial. Timekeepers, please start the clock and announce when 3 minutes has come.
Chris.
Should be. Okay,
Or you can, why don't you tell? No, because you can announce it. Sure. Yeah.
Yeah, that's what I was thinking. Yeah, of course, you didn't do this.
It's a very opening in the middle. I need to get in there. You don't want to go.
Not-
30 seconds.
We are now ready to begin this trial. To give the parties an opportunity to handle some brief housekeeping matters. I'll start with counsel for Justice Carver.
Yes, Your Honor. Good afternoon. My name is Violet Wu. Before we move on to housekeeping matters for the plaintiff, permission for my co-counsel, in addition to our witnesses, to introduce themselves.
Let's start with the attorneys. It would be of great help if you would enter your appearance by stating your name and spelling your last name. So we have Counsel Wu and your last name spelled out.
Yes, Your Honor. It's spelled W.
Thank you.
Yeah, can we get the ruling first before?
Oh, before housekeeping, I apologize. The court, and thank you, Counsel Wu. The court thanks counsel for the argument, is ready to rule based on the argument presented today. The court denies the motion to eliminate. Accordingly, Court finds that the 20 Imperial Civil Code, Section 2007, the Responsible Firearms Sale Practices Act, as applied in this case, is unconstitutional under the Second Amendment. Since the court has denied the motion, Justice Carbo's second cause of action is dismissed with prejudice, not pursuing trial. Additionally, exhibits 16, 17, and 18 are excluded from evidence under the Imperial Evidence Ordinance 402. This concludes the pretrial argument. The court is ready to move on to trial. Thank you very much, jurors. I have Counsel Wu's appearance. Counsel.
Good afternoon, Your Honor. My name is Brianna Tota. That's Tota.
Thank you.
Good afternoon, Your Honor. My name is Arya Parekh. That's Parekh.
Thank you. We'll have the witnesses introduce themselves as they come forward. And so we don't need any of that. We have all the background information we need here otherwise, and I will get the other counsel when I get them. But with that exception, is there anything else by way of housekeeping?
Yes, Your Honor. The plaintiff has a few housekeeping matters we would like to address.
Please.
Firstly, we would like to remind the court of Rule 615 as per Imperial rules, which states that all witnesses are constructively sequestered with the exception of party representatives.
That's correct. And do we have a party representative on the defense side today? Do we? No. And not on the plaintiff side today?
Well, Your Honor, the party representative for the plaintiff will be Justice Carr.
Very good. That's that motion, if we want to think of it that way, is granted based on the instruction of the chief judge earlier today in briefing us. Apparently, it's helpful to remind everyone that if this were a real trial, at this point, all the witnesses, other than those who have been specially designated, would leave the courtroom, remain outside, and would only be called upon to re-enter the courtroom when their testimony is needed. And so the court takes the opportunity to remind everyone of that.
Yes,
Thank
Your Honor.
you. Anything else?
Yes, Your Honor. The plaintiff asked for permission to move about the well during examinations and statements.
All counsel may utilize the well with the following exceptions. You must ask to approach the jury, the witness box, the witness stand, or the bench. Also, no one, counsel, witnesses, or spectators may utilize the equipment back here behind the judges. That includes the water fountain, except during breaks.
Yes, Your Honor.
Yes. Anything else?
Yes, moreover, Your Honor, the plaintiff wanted to ask about your preferences in regards to objection procedure, whether you would like us to stand and immediately state our grounds, or if you would prefer us to stand and wait to be acknowledged before stating our grounds.
No, the court would appreciate that you stand, state the word objection, and perhaps a brief summary to clue us all in as to what you found objectionable.
Yes, Your Honor.
Thank you.
Furthermore, Your Honor, as per stipulation 12, the plaintiff would like to remind the court that our expert, Dr. Morgan Judd, has been stipulated as an expert in firearm safety, and their methodology has been accepted in firearm safety and public policy.
I'm aware of the stipulation, and let me, whatever it's worth, share with you what the chief judge has shared with us, which is that counsel, notwithstanding that stipulation, is still expected to proffer experts when appropriate, and at that point the court will undertake a pro forma ruling based on the stipulation.
Yes, Your Honor. And finally, the plaintiff does have an intent to offer character evidence form, which has been signed by both our side and the opposing counsel. If you would like a copy.
Yes, please.
May I first bench, Your Honor?
Yes, please. Thank you very much.
Yes, Your Honor. With that, the plaintiff is ready to proceed to trial.
Thank you, counsel. Any housekeeping matters on behalf of the defense?
Yes, Your Honor. First, I would like to say that prior to today, both the defense and the plaintiff a set of stipulation trial orders. Your Honor, like a copy?
No, I believe I have them, but if further issues arise, I can certainly make use of yours.
I'd like to remind the court of stipulation 8, which states that Exhibit 1 will be admitted in its entirety to evidence.
The court is aware of that and understands that, and I believe I saw that Exhibit 1 is in the podium. Very, very good. Thank you very much.
I would also like to amend stipulation 13, which states that Duck and Stop will be admitted as an expert in firearm and thus can give expert testimony in this.
Again, reference my previous remarks regarding the other experts, and we'll deal with them when they come.
And lastly, could my team introduce themselves?
I would like very much for you to enter your appearance, and if we could begin with you, that would be fantastic.
I'm Tara Walton, that's WALSON.
Very good, thank you.
My name is Dylan Shafko, SZATKO.
Thank you.
Good afternoon, my name is Ryan Sliwa, SLIWA.
Thank you very much. With that, is that the remainder of housekeeping matters for the events?
Yes, Your Honor.
Thank you very much. Before we begin, I'd like to let both parties know that I will take a moment after each statement or examination to ensure our judges have been able to submit their scores and comments into the tabulation software. I know all of us went through the experience this morning of not having, for now they're up and running. Counsel for Justice Carbo, when you are ready, you may begin your opening statement.
Yes, Your Honor. I was just gonna ask if I can have permission for co-counsel and I to move the podium just for my own.
I'd be delighted, if it is movable, I'd be delighted for whoever wishes to volunteer to move it out of the way for the remainder of the trial. Is there a napkin in the house?
Apologies, Your Honor. I'm saying.
No worries. Hey, what, give me one. That's what I'm just put it in there. And you guys, do you need a hand? Oh, wheels are good. For purposes of this exercise, if you want to do that way, you can't just get it out of it. Thank you to the coach or teacher who just secured the napkins very much. Also still doesn't. You have all your stuff.
Yes.
And we survived. We thank you. And thank you for your grace and forbearance, and we thank all of the plaintiffs' counsel for jumping in. With that out of the way, counsel for Justice Scarbo, whenever you're ready, you may proceed.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. At a gun range, safety cannot come down to a matter of feet. But on May 28th, Justice Carbo's safety did. Justice Carbo had lived in Empyrean her entire life. Empyrean was her home. But for the past years, it hadn't been the same. Her car had been broken into not once, not twice, but 3 times. She no longer felt safe. So, what did she do? She did what many in her position would do, and decided to buy a gun for self-defense. Now, Justice Carbo had never used a gun before, so she wanted to be extra cautious. She did extensive research and even emailed the gun club before going in person. Finally, on May 28th, Justice Carbo walked in the Shooting Star Gun Club to buy a gun. Little did she know, she would not walk back out. She would leave in an ambulance after getting shot instructor, Drew Cantrell. Members of the jury, today the plaintiff brings one cause of action against Shooting Star. That Shooting Star negligently hired, supervised, and retained their employee, Drew Cantrell. To do this, we have the burden of proving by a preponderance of the evidence. That means, more likely than not, 3 facts. 1, Drew Cantrell was unfit as a firearm instructor. 2, Shooting Star knew about it. And 3, Shooting Star's employment of Drew Cantrell was the direct cause of Miss Carbo's injury. Today we will be calling 2 witnesses to the stand. 3 witnesses to the stand, one of which is Dr. Morgan Judd and another is Ross Hernandez. Dr. Judd is an expert in firearm safety, and Mix Hernandez is a regular at Shooting Star's Cafe and Bar. We expect their testimonies will reflect Mr. Cantrell's history of unsafe gun use. We expect Dr. Judd will testify to 2 of the most basic gun safety guidelines, and will tell you how both of these guidelines were violated by Mr. Cantrell on 2 separate occasions. We expect Mix Hernandez's testimony will reflect Ms. Cantrell's history of unsafe gun use, and they will tell you how they will reveal their eyewitness accounts of this unsafe gun use. What's more is they will describe how every time they witnessed Mr. Cantrell shoot a gun, he would miss the target altogether. Next, you will see that Shooting Star knew about this unfitness. We expect you will hear that both of these incidents were written up, but Mr. Cantrell received no retraining, no supervision, no suspension after these violations in basic gun safety. We expect you will hear that Drew Cantrell violated rule after rule and Shooting Star did nothing until he shot someone. We expect you will hear that upon hiring, Drew Cantrell was asked no questions about experience with professional gun handling, no questions about past employment or criminal record, and received no training from Shooting Star. He was working in a gun club. Finally, you will see that Shooting Star's employment of Drew Cantrell was the direct cause of Miss Carbo's injury. We expect you will hear that we expect Dr. Morgan Judd will testify to the importance of knowing your surroundings before shooting a firearm. Mr. Cantrell placed Miss Carbo in a position where, 1, it was impossible to see her, and 2, was mere feet away, making it possible for any small movement to cause a collision. Members of the jury, the negligent employment of Mr. Cantrell caused Miss Carbo's safety to come down to a matter of feet. But at a gun range, in a safety course, there is the expectation that people are kept safe. Miss Carbo was not. We ask that you find the defendant liable, because at a gun range, safety cannot come down to a matter of feet. Thank you.
Thank you. Counsel for Shooting Star Gun Club, you may proceed with your opening statement.
Yes.
Court, Your Honor, opposing counsel, and ladies and gentlemen of the jury. This is a case of how improvement is not incompetence. Skylar Coleman started working at Shooting Star Gun Club when they were a teenager. It was run by their parents. Skylar Coleman took over running Shooting Star Gun Club because there was a boom and firearm sales in Purion, and their parents were getting old. After Skylar Coleman took over running Shooting Star Gun Club, they implemented lots of new safety precautions and even implemented a tavern which brought in many new customers, some of whom had no interest in firearms. In May of 2020, Skylar Coleman hired Drew Cantrell as a salesman. Drew Cantrell wanted to be a safety instructor. However, Drew Cantrell did not have a safety certificate to be a safety instructor, and Shooting Star Gun Club already had a safety instructor. In May of 2021, 1 year later, there was an issue with Drew Cantrell at Shooting Star Gun Club. However, Skylar Coleman properly handled the situation and made sure it never happened again. During this time, the current safety instructor at Shooting Star Gun Club parted ways with the company. Skylar Coleman hired Drew Cantrell as a safety instructor. This is because in November of 2020, Drew Cantrell had acquired proper safety certificates they needed in order to be a safety instructor. In November of 2021, there was a different issue regarding Drew Cantrell at Shooting Star Gun Club. However, again, Skylar Coleman properly handled the situation and made sure it never happened again. On May 28th of 2022, 7 months later, Justice Carbo came to Shooting Star Gun Club wanting to purchase a firearm. Skylar Coleman recommended the Glock 22 because it was a beginner-friendly firearm. Skylar Coleman then ran a background check of Justice Carbo and made sure all the proper legal documentation was signed. Skylar Coleman then informed Justice Carbo that they would be taking a safety course taught by Drew Cantrell. Drew Cantrell then led Skylar Coleman and Nick Allred, another new gun owner, into the gun range. Drew Cantrell started by giving basic safety instructions and rules of firearms. Drew Cantrell then tried to move on to demonstrating how to hold and fire the firearm. However, Justice Carbo moved too close to Drew Cantrell. When Drew Cantrell went to fire the firearm, Justice Carbo jumped and bumped into him, causing the firearm to fall and fire into Carbo's leg. Today, the defense will call for 3 witnesses. First, the defense will call for Drew Cantrell. Drew Cantrell will testify to the events that happened at Shooting Star Gun Club on May 28th of 2022 and prior. Drew Cantrell will also testify to the safety precautions at Shooting Star Gun Club. The evidence will show that Shooting Star Gun Club took safety very seriously and took every precaution necessary. Next, the defense will call forth Avery New. Avery New will testify to the events that they saw at Shooting Star Gun Club on May 28th of 2022. The evidence will show that Justice Carbo was too close to Drew Cantrell, causing the events that took place. Avery New will also testify to more safety precautions at Shooting Star Gun Club. The evidence will show that Skylar Coleman took every precaution necessary to have a safe gun club. Lastly, the defense will call for Officer Jackie Staub, an expert in firearm mechanics. Jackie Staub will testify to Drew Cantrell's handling of the firearm on May 28th of 2022. The evidence will show that Drew Cantrell properly handled the firearm on this day. Jackie Staub will also testify to the claims brought forth by the plaintiff. The evidence will show that Shooting Star Gun Club was not negligent in their hiring or retention of Drew Cantrell. The events that took place on May 28th of 2022 did not happen because of negligence. The events that took place on May 28th of 2022 happened because Justice Barbeau was too close to Drew Cantrell. The events that took place on May 28th happened because Justice Barbeau did not know how to conduct themselves in an area where guns were being fired. Today, the plaintiff has the burden of proof. The plaintiff must prove by a preponderance of evidence their claims. However, the plaintiff will fail to meet this burden. Then we, the defense, will ask you, the jury, to find the defendant, Shooting Star Gun Club, not liable. Thank you.
Thank you. We'll give the judges a moment to enter their scores, comments. Plaintiff Carbo may present its case as per the special instructions. You are required to call Justice Carbo as your first witness.
Yes, Your Honor.
And for the benefit of Counsel Wu and all attorneys, once I have indicated that we're ready for your next witness, you don't have to ask further permission to address the witness to begin your examination.
Yes, Your Honor.
Yes.
Good afternoon, Ms. Carbo. Could you please introduce yourself to the court?
Good afternoon, my name is Justice Carbo, and I'd say I'm a local here.
Could you tell the court why you're testifying today?
I'm testifying today because I don't let what happened to me on May 28th of 2022 to happen to anyone else. I want to ensure that there's no more victims such as I. This is all because on May 28th of 2022, I was shot by Drew Cantrell.
I'm so sorry to hear that, Ms. Carbo. Before we get to talking about that day, let's allow the court to get to know you a little bit. Have you always lived in Imperial?
Yes, I've always lived in Imperial. I actually grew up there with my parents. They were also born and raised in Imperial. So I grew up in West Pascal, which is not technically East Pascal. Though we had some struggles, I guess, say financially, I really was taught well by my parents to have good character, and that's what actually got me a scholarship. So I'm pretty proud of my upbringing.
Ms. Carbo, do you still live in West Pascal?
Yes, I do.
And how would you describe living there?
I love the local zone, but things are starting to get a bit dangerous as crime is rising.
Could you elaborate for the court what you mean by that?
So I've actually been walking home before. I've had my car broken into 3 times, and I wasn't really feeling safe. I mean, I've tried something, but I guarantee that none of them would ever try to take me. So I thought that maybe it'd be best to purchase a gun.
Let's talk about your experience purchasing that firearm. What was your top priority when you were looking into places to buy it from?
I really want to make sure that rather than just purchasing the gun, I'd also be receiving a training because, you know, I'm new and I really want to shoot some eye out. So I heard of Shooting Star Gun Club LLC from word of mouth mostly.
Did you contact anyone at Shooting Star?
I actually spoke to Skylar Coleman via email from May 3rd to 5th, 2022. I mainly discussed how, you know, I'm new, I went this training and all, and what the recommendation just to get a whole feel because I wasn't really sure on the thing. But the responses weren't really bad.
Did you ever mention to Ms. Coleman that you were new to firearms?
I mentioned it quite a bit, I'd say. I mean, I never made a public gun in my life.
Did you ever go to Shooting Star Gun Club in person?
Yes, after I wasn't really feeling satisfied with the emails, we decided to meet up in person on May 14th, 2022, which was a Saturday. And there I discussed again that I'm new to guns, I wanted my training, and what were the recommendations.
On May 14th, did Ms. Coleman mention anything about you taking a safety training course?
I mistake they didn't. I had to actually bring it up myself again, which was honestly really strange because I mentioned the emails prior.
When you had to bring up the safety training course, how did Ms. Coleman respond?
They were a bit, their response was interesting to say the least. They told me it was my prerogative.
Question, hearsay.
Remain standing. What statement do you, have?
The statement that Ms. Coleman stated that it was Carbo's prerogative. This is a quote from Coleman, who was not present in court to testify herself, and it is decided, hence it is used.
Counsel.
Yes, Your Honor, we're not using the statement for the truth of its contents, rather, or we're not using the statement to prove that it was actually Ms. Carbo's prerogative, whether or not she was to take this training course, but rather to demonstrate that Ms. Coleman did not prioritize Ms. Carbo's question or inquiry into the safety training course.
Overrule the objection.
Yes, Your Honor.
If you wish to have the question reposed, or if you could answer it, you may proceed as you wish.
Yes, Your Honor. When you mentioned the safety training course, how did Ms. Coleman respond?
It was really strange, honestly. They said it was my prerogative, air quotes, if I really wanted to say if I can take it. Obviously, I insisted I must take it. We agreed to meet up again on May 28th, 2022, which was also a Saturday for my training and my.
So what day was it that you returned to safety or to Shooting Star Gun Club for your training course?
May 28th, 2022.
Let's talk about that day. What was the first thing that you did when you went to the gun range?
I had to fill out some forms again, and then we were saying I was good to go on my way, which I had to then tell them again that I needed my training course. That's when they introduced me.
Objection narrative.
That is when they introduced me to Drew Cantrell, who I was informed would later be my shooting instructor.
Ms. Carbo, what was your first impression of Drew Cantrell?
It seemed almost to me at least that they were a bit surprised by this. They hadn't, the reaction.
Objection, speculation.
I'll hear you on that. What exactly is the speculative?
What is speculated that Drew Cantrell was unaware of the training course, which is the fact that they have no way. Yes, Your Honor. Ms. Carbo was merely testifying to her perception based on the foundation that she's laid in terms of how Ms. Cantrell reacted to the information that we would be running the safety course. She was basing her perception of Drew Cantrell on that action by her.
Anything down? You don't have to have anything down, just ask.
Yes, Your Honor. The witness stated it seemed as though Cantrell didn't know what they were saying or didn't know about the training codes, and therefore his answer is inherently speculative. And as well, additionally, even if it was merely Carbo's interpretation of the events, then I would bring up the question of relevance as to why Carbo's feelings about Cantrell's appearance would be relevant.
The objection will be sustained. Part the jury will be instructed not to regard her comments as relating to the actions of the particular individual, but her own perception of how the individual is communicating information. You may continue.
Yes, Your Honor. Ms. Carbo, how did Ms. Cantrell react to Ms. Coleman telling her that she would be running this?
To me, at least from what I perceived, it seems as if they were a bit shocked by this, based off of and their facial expressions.
Ms. Carbo, let's talk about the safety course on that day. How did it start?
Well, they led me over to the stalls, which had about 12 stalls, I'd say, and I was directed to stall 11. There was also that person, Avery Wynn, at stall 3. But I don't like pay much attention to them because they were so far away.
And were there any more customers taking the safety training course?
Yes, there was another person, Nick Allen.
Where were you standing in stall 11?
So Drew actually directed me to stand behind them and a little bit towards the right. It was a little bit close to me, I think, honestly, but they were the expert and I had no real idea about guns where I should be standing, so I really go against them on that.
Did you have a clear view of Ms. Cantrell from where you were standing?
Yes, they made sure to tell me to pay attention to like their own movements, so I know where they're shooting at the demonstration. It's also paying really good their body.
What happened when Ms. Cantrell fired the gun?
So it's this weird twitchy flip treatment I've never really seen before. And they shot the first shot. After they shot the first shot, they directed the gun towards me, shot me.
Ms. Carbo, did you ever move from the position that you were told to stand in?
Of course not. I made sure that I was standing right there.
What happened after the second shot was fired?
Like I said, I was shot in the leg and fell to the ground. Someone must have called 911 because I was carried out.
So sorry to hear that, Ms. Carbo. Thank you for your testimony. I'm not being heard.
Thank you. Any cross examination?
Yes, Your Honor. Permission to move the stand. The stand.
Would it be possible for, the court will keep the stand out of the well for directly cross? They certainly carry your notes with you.
Good afternoon, Ms. Carbo.
Good afternoon.
Now, your car has been broken into 3 times, isn't that right?
Unfortunately.
And your house was broken into as well? In fact, it was getting to the point where you did not feel safe in your own home, correct?
It wasn't the cats not really doing anything to protect me.
So, you felt like you needed to protect yourself, true?
Yes, but honestly, in further hindsight, there's plenty of actions I could have taken instead of buying a fire.
Ms. Carbo, is that a yes to my question?
Yes.
Thank you. You felt that having a firearm would give you some peace of mind, right?
That is what I thought.
Now, you initially found out about shooting Star gun from through word of mouth, correct?
Yes, and that annoyed Jim.
And you also saw some Yelp reviews, right?
That is correct.
And based on what you said, it seems like it had everything you wanted, right?
So I really want to receive my training and the gun stopped in.
So you emailed the owner of Shooting Star, Skylar Coleman, right?
Yes,
But you felt like their responses over email were insufficient.
I did not think there were good answers now.
But then again, this was over email, correct?
That is correct.
So Coleman suggested that you come to the shop to speak with someone in person, right?
Yes, because it really didn't answer any of the questions I asked.
And so you came into Shooting Star.
That is correct.
You felt at ease when talking to Coleman, correct?
Yes, they're very persuasive.
Yeah, in fact, in person, they were nothing like how they were over email, is that right?
Yes, tone sometimes doesn't carry through, so I give them the benefit of the doubt.
Exactly. So when you were in store, Coleman answered your questions.
Yes,
After answering your questions and giving you a detailed description about gun ownership, Coleman recommended to you the Glock 22.
that is what I reject.
Objection, Your Honor, to hearsay. I mean, if I may be heard.
Sure.
Your Honor, we believe that opposing counsel will be using this testimony, specifically the statement that Ms. Coleman told Ms. Carbo to buy the Glock 22, in order to prove that the Glock 22 is in fact an appropriate handgun for beginners, and for that reason, we believe that they're using this out-of-court statement for the truth of its contents.
Counsel,
I have not stated anything about the
so
Glock.
to direct your comments to the bench.
I apologize.
No worries.
Your Honor, I have not stated anything suggesting that the Glock 22 is appropriate on a firearm for beginners. This was not part of my questioning. I was simply asking which handgun was recommended.
So, counsels, as I understand it, your objection is hearsay,
Yes, Your Honor.
and that this statement is being offered for the truth. So is this statement hearsay?
No, Your Honor,
And tell me why.
because I'm not using this to prove the truth of the matter in any way that the gun was appropriate for beginners. Once again, I said nothing about that. I'm simply using it to explain why Carbo had a Glock 22.
I will overrule the objection.
Yes, Your Honor. Would you like me to repeat the question, Ms. Carbo?
Sure.
So, after answering your question, Skylar Coleman recommended the Glock 22, correct?
That is correct.
Once you decided to purchase the gun, Coleman had you fill out some paperwork, right?
They did.
Now, you asked Coleman for a training course at this point, correct?
Yeah, so it's really strange to bring it up again, but yes.
And Coleman did agree to give you one, didn't they?
Yes,
They told you to come back in 2 weeks for the course, right?
they did.
Additionally, Coleman did not let you take home or even purchase the firearm until the day that you were returned to take the training course.
I can't really say for sure if they would allow me to walk out, because I insisted I must have that training.
So 2 weeks later, you came back to Shooting Star, didn't you?
Yes,
When you came in, Coleman had to run a background check, correct?
I assume they ran a background check. I can't really say for sure, they kind of sequence fill all this.
That is what they said they were going to do, correct? And after this, isn't it true that they also had you fill out some paperwork
Yes,
One of these pieces of paperwork was a liability waiver, correct?
that is correct.
If you were shown a copy of the. Let the record reflect that I am showing opposing counsel what has been marked as exhibits that are for identification. Permission to approach the witness with the evidence.
I, before I was not looking up, you did share it with counsel?
Yes, I did.
Yes, please,
Would your honor let me first?
please.
Now, Ms. Carver, you recognize this document, do you not?
Yes, I did.
And this is the waiver that you filled out that day at Shooting Star, right?
Yeah.
You recognize that at the bottom of this document, there is your signature,
It appears to be so.
and if this is a fair and accurate representation of the waiver with your signature on it, correct?
Yes.
Now, when you signed this waiver, you saw,
Objection, Your Honor.
Have the question.
I'm sorry, may I restate my question?
The court has not heard a complete question yet, so please just, if it's a question, they remain standing.
Yes, Your Honor. Now, when you signed the waiver, you saw that the first paragraph of the waiver states that the signer releases Shooting Star Gun Club from all liability for losses and damages that happen to the signer, correct?
Counsel.
Yes, Your Honor, I'm going to object because opposing counsel is asking questions about an exhibit that has not been entered into evidence.
I'll sustain.
Permission to enter the exhibit into evidence.
So I hear you move it into evidence, correct? Any objection?
Yes, Your Honor, I'm going to object under Rule 403, more prejudicial than probative, if I can be heard on the ground.
Please.
Your Honor, we believe that opposing counsel is using the fact that Ms. Carver signed this waiver to bar the claim for negligence, and that under Rule 403 would be misleading the jury. If I may direct your attention to a piece of case law, McAndrew v. Garg Skydiving Adventures, which states that as a matter of public policy, the presence of a signed liability release or waiver will not serve to bar a plaintiff's negligence.
Thank you. Counsel response.
I'm not attempting to negate the allegation of negligence. I'm simply trying to further explain the story in parts that the plaintiff left out and explain why, and explain Justice Carver's awareness.
So could you, that last one was the part that intrigued me. What is its relevance to your case if it is not for the purpose of explaining liability?
It's for the purpose of showing that Justice Carver was fully aware and informed of the potential dangers of the firing range.
Thank you. Anything further, briefly?
Yes, Your Honor. Briefly, we believe that the probative value that has just been stated by opposing counsel is not sufficient as it is overly prejudicial and misleads the jury.
So the objection will be granted in part. The jury will be instructed that Exhibit 7 is not relevant as to release of liability in this case or at any other time, but can be considered their consideration of knowledge of victim of the circumstances of gun use.
Yes, Your Honor.
Permission to continue.
Yes, 7 is admitted under those circumstances.
Thank you. Permission to publish to the jury.
Certainly.
Ms. Carville, I'm going to repeat my question. When you signed this waiver, you saw that the first paragraph states that the signer released the Shooting Star Gun Club from liability for all losses and damages that happened to the signer, correct?
That is correct.
And this includes losses that occurred due to negligence, correct?
Yes.
Next, doesn't the waiver state that the signer is aware of the dangers associated with being in the fire?
Yes, but I never really expected someone who's supposed to provide me with safety would take it away from me.
But in response to my question, that is yes. Thank you, Ms. Fargo. And now this document, once again, it holds your signature, isn't that true?
Here, so.
Thank you. Permission to approach the witness to retrieve the evidence, Your Honor?
No, we'll leave it up here for now.
Yes, Your
You're
Honor.
talking about Exhibit 7, right?
Yes,
Unless you need it.
No.
Okay, we'll just leave it on the witness stand for now. It is that.
yes, Your Honor. So after you finished filling out the paperwork, you went to the back with Drew Cantrell for your training, right?
That is correct.
At this point, you also met this other new gun owner named Ulrich, right?
Yes.
Cantrell once again explained basic safety rules to you, didn't he?
That is what I assume is the basic safety, yes.
He also explained how to follow those rules, right?
Objection, Your Honor, to hearsay.
I'll hear you.
Yes, Your Honor. Opposing counsel is asking questions about what instruction and information was given by Ms. Cantrell to Ms. Carver during the safety training course. Specifically, the statement being elicited is whether or not Cantrell laid and explained the proper way to follow gun safety rules to Ms. Carver. We believe that that is an out-of-court statement being used for the truth of its contents.
Counsel?
Two responses. Firstly, I'm not asking the witness to state exactly what was stated. Secondly, this is not being used to prove that the truth of the matter of what Cantrell said, simply to prove that it was stated, and hence it is not to prove the truth of the matter, and it's not.
I'll overrule the objection on that second basis.
Yes, Your Honor.
May I repeat my question?
Do you need it repeated?
Yes, please. Okay. So Cantrell explained how to follow the safety rules, right?
Yes,
He also explained how to follow them.
yes,
He explained how to be safe with a firearm.
yes,
For example, he showed you how to keep your index finger outside of the trigger when explaining to you never to keep your finger on the trigger when holding the gun, correct?
that is what was explained.
He also told you to treat every gun like it was loaded
Yes,
and to never point a gun at another person unless you intended to shoot them.
yes,
And it looked to you like he was being safe while performing this demonstration. Isn't that right?
Objection, Your Honor, to improper lay witness opinion, and may be heard on this ground.
Certainly.
Your Honor, opposing counsel is asking the witness to testify as to whether Ms. Cantrell was being safe in their demonstration. And we've already established that Ms. Carbo is completely new to guns, has never been in a gun range before, and has never taken a gun safety course, and it would therefore be improper for this witness to testify to that.
Counsel,
Yes, Your Honor.
are you eliciting an opinion with regard to safety?
No, Your Honor, I'm not asking the witness if what Cantrell was doing was safe. I rather asked their perception of the event.
Counsel?
Your Honor, I believe the question was whether this witness thought that Ms. Cantrell's conduct during the safety course was safe.
Will sustain the objection.
Yes, Your Honor.
So, next, Cantrell demonstrated how to fire a gun, right?
fortunately, yes,
Before doing this, he gave you an alright eye and ear protection.
it's not gonna really stop a bullet, but right,
He instructed you to watch how he was shooting, not where he was shooting, right?
yes, that's always paying close attention.
Now, after the first shot went off, you claimed to have seen Cantrell's hand move suddenly, correct?
It's a weird jerky.
But you didn't see exactly how much his hands moved.
Can't really measure in any form now.
Is that a no to my question?
Can you please restate the question?
You did not see exactly how much Cantrell had.
Correct, I did not see how much. His hands.
Thank you. So, and you weren't really paying attention to where the bullets went.
No, I was more paying attention to what he was doing rather than where it was going, because that's what he instructed us to do.
Hence, you cannot say for certain that it was this sudden movement that you believe you perceived that caused Cantrell's hand to drop the gun and fire into your leg.
I didn't say that.
But you cannot say for certain that this is what led to you being shot.
Objection, Your Honor, to assumes facts not in evidence.
Can you explain?
Yes, Your Honor, this witness has already established that it was nowhere in her testimony that she felt that the flinch.
So she has testified to that. And now he's gonna have another question, I believe. So let me overrule your objection, make sure I understand what's going on. You may have a very good basis, you can reassert it in just a moment.
Yes, Your
She
Honor.
has said that that wasn't her testimony. What is your next question?
Yes, Your Honor. My next question is actually unrelated.
Okay, so I think then we're back on track. Okay, go ahead.
Yes, Your Honor. So, Ms. Cantrell, moving on. You believe that guns are meant to kill other living things.
I believe they can be used for such things, but we also use for other stuff as well.
You believe that guns cause more harm than good.
I do believe that, yes.
And now you're vocalizing, aren't you?
Yes, I believe everyone has pretty left or right views on guns these days.
In fact, you're involved in anti-gun advocacy here in Imperial. In fact, you started your own nonprofit called Empyrean Against Gun Violence.
Yes, I really want to ensure that no one else can be harmed in the future with accidents like this.
And Mrs. Carbo, here in court today, you intend to take every last penny from Shooting Star.
Objection, Your Honor, argumentative.
Overruled.
Yes, I believe that taking shooting stars money would prevent them from further being able to inflict harm on others and cause more victims such as me. So if I must take every single penny, that is what I will do.
And you will take every last penny, even if it's the last thing you do, correct?
That is what I said.
Thank you. No further questions, Your Honor.
Thank you. Any redirect in light of those questions?
No redirect, Your Honor.
Thank you. Witnesses thanked and excused. Very good. Just quick for the court's benefit, it may not help the attorney's office, for the court's benefit. Can I get a quick crime check on where we are? Okay, thank you. Just a moment, we'll get that, and then you can call your next witness. How much time does the plaintiff have remaining?
Yes, Your Honor, the plaintiff has 42 minutes and 58 seconds remaining.
And defense?
The defense has 40 minutes and 19 seconds.
Very much. And I apologize if I didn't say this before, Ms. Carbo, you may, you're excused if you wish to. Do you have any other witnesses?
Yes, Your Honor, the plaintiff calls Ross Hernandez to the stand.
Please.
Good afternoon, Mr. Hernandez. Good afternoon. Could you introduce yourself to the court? Of course. My name is Ross Hernandez. I was born and raised in West Pascal, Imperial, and I am the owner of a cupcake shop called For Old Times Cake, which I started in 2012. Where is your shop located? My shop is in a strip mall with some other businesses like Shooting Star Gun Club. Let's talk about Shooting Star Gun Club. Do you ever visit? Yes, I typically visit about 4 times a week to eat lunch, see friends, or just take a break at the cafe and bar, Shooter McTaverns. No, I own a cupcake shop, but I just can't eat cupcakes all the time. I'm also in the range of occasion, though I don't shoot guns myself. Are you familiar with the owner of Shooting Star? Started home. Yes, I am. I see them and the many ads around town for Shooting Star fairly often, and I would say that we're friendly. After seeing these advertisements, did the number of customers coming to Shooting Star change at all? I would say so, yes. It seems a lot busier than it used to be. A lot busier than my place for sure. I'm not sure why anybody would rather buy a gun than a cupcake, but to each their own, I guess. Are there any other major events that have brought more customers to Shooting Star? The opening of Shooter McTaverns did, for sure. It drew in a lot more customers who, like myself, never used guns and then who ended up buying guns from the shop and then walking straight out with them. What do you mean by walking straight out with them? They purchased the guns and then left the store without anything happening in between, like shooting at a range or something. Are you familiar with any of the employees that sold those guns? I couldn't tell you who sold which guns specifically, but I do know most of the employees just from being around so often. Are you familiar with an employee named Drew Cantrell? Yes, I am. I know that they're a gun safety instructor and I've seen them do private practice in the range. To be honest, it's not quite what you'd expect from a gun safety instructor. What do you mean by that? Well, every single time I've seen them shoot, they always miss to the right, occasionally hitting the neighboring target. I think it's a bit odd that every single time I see them shoot, they miss. That would be like if I burned every single batch of cupcakes that I made. How would you describe your relationship with Drew? We aren't friendly just because of an incident that I witnessed. What was the incident that you witnessed? I saw an incident in May of 2021 where Drew Cantrell was unsafe with a gun, and I also heard some stuff that was a bit out of the ordinary in November of 2021.
Let's talk about the May incident. What were you doing at Shooting Star?
I had gone for lunch and I was talking to a friend in the shop.
How did you become aware of it?
I heard some noises behind me and I turned around to the side of what seemed to be an argument between Cantrell and another worker. Judging from the way Cantrell was glowering intimidatingly at the other employee.
Was that the end of the incident?
No, it wasn't. Drew Cantrell was holding a gun by their side in their right hand, and then all of a sudden they lifted their arm and they pointed the gun at the other worker.
Did anyone else witness that?
Yes, Skylar Coleman did, and judging from the fact that they yelled louder than I've ever heard them before, I would say they seemed pretty upset.
Did Drew Cantrell and Skylar Coleman speak after that?
Yes, they did. They spoke in the back office.
And did you see Skylar Coleman again after that?
Yes, I did. They came out of the office and took some notes about the incident.
Let's talk about the November incident. Were you present at Shooting Star that day?
Yes, I was. I had wanted to chat with Skylar about a vacation that I was planning to Japan, in case anyone was wondering.
And did anything seem out of the ordinary?
Yes, the shop was really quiet and totally empty, but I could hear Skylar Coleman yelling in a really lecturing tone from the office where they and Drew Cantrell were.
Thank you, Ms. Hernandez. No further questions, Your Honor.
Thank you, cross-examination.
Yes, Your Honor. Ms. Hernandez, you're good friends with Skylar Coleman, correct?
Well, I would say we have a friendly relationship.
You guys like to gossip, correct?
Yeah, we do gossip a little bit sometimes.
You guys have been business, right?
Yeah, just because we both run businesses in the same strip mall, sometimes we can, feel each other's head, just talk each other out a little bit.
You two just enjoy each other's company, right?
Yeah, generally I would say so.
You guys mostly hang out at Shooting Star Gun Club, right?
Yes,
You go there around 4 times a week, yes?
yes, 4 times a week.
You spend most of your time here at Big Taverns, correct?
Yes, most of the time when I'm at Shooting Star, I'm in shooter.
This is because you have no interest, correct?
No, I wouldn't really call myself a gun enthusiast.
However, you are familiar with the work at Shooting Star Gun Club, correct?
I would say decently familiar.
You're familiar with your control, yes?
Yes, I do know of them.
You don't get along with your control, do you?
No, we have our differences.
You once even said that Drew Cantrell was a bad shot, correct?
Yes, I mentioned that every single time I see them shoot, they always miss in the exact same way, and it's pretty dramatic.
But you've only ever seen Cantrell shooting 3 or 4 times, correct?
I would say yes on that many occasions.
And you spend most of your time here in the tavern, correct?
Yes.
And you can't see the gun range from the tavern, can you?
No, but I have been in the range before as well as the shop.
Moving on. You were not at Shooting Star Gun Club on May 28th of 2022, were you?
No, I was not.
You heard about the event that transpired here a few days later on the news, right?
Yes, I read an article about it in the Chronicle Times.
But you weren't surprised when you heard that this involved Drew Cantrell, were you?
No, after seeing the ways that Drew Cantrell disrespected what I assume was gun safety, judging Skylar Coleman's reaction, it didn't really surprise me that much that they would do something like that and hurt a customer.
This is because of 2 prior incidences, correct?
Yes, it is.
The first incident happened in May of 2021, yes?
Yes.
This incident involved a gun and another employee, correct?
Yes, it did.
You recall seeing Skylar Coleman get really mad and angry at Drew Cantrell, correct?
Yes, I did.
Skylar Coleman then asked you to sign a form regarding what you witnessed that day, correct?
Yes, they came up to the office after and they wrote some stuff down about the incident.
In November of 2021, you recall a different incident, correct?
Yes.
This incident regarded procedural issues regarding gun safety, correct?
That's what I heard of the shouting from the office, but because I wasn't there, I can't tell you every single thing about what happened.
But you know that this incident was different than the first, correct?
Well, I can't be 100% sure in what ways it was different. I assume that the exact same thing didn't happen twice, so I guess so, yes.
To your knowledge, Neither of these two events happened again, correct?
Not to the best of my knowledge.
Objection, speculation. May I elaborate?
No, I think we understand, Counsel.
I'm simply asking what this witness knows and does not know. I'm not speculating if it happened again or not. I'm asking if this witness knows.
Call for her to speak.
No, I'm just asking if she knows or not. I'm not asking.
Counsel.
Yes, Your Honor, I think the opposing counsel is asking the witness if another incident occurred after this, and the witness wouldn't be able to testify to that as it's out of their scope.
It's, the objection is well considered, but it's crossed. We'll see what she knows.
Yes, Your Honor.
So do you need the question reposed?
Yeah, that'd be great if possible.
To your knowledge, did either of these two events happen again?
Not to the best of my knowledge, no.
Makes sense. To your knowledge, did any event happen before May of 2021?
No, not to the best.
To your knowledge, did any other event happen after November of 2021?
Other than the incident on May 28th, no.
So to your knowledge, nothing happened, nothing else happened except for in between those 6 months, correct?
No, I don't recall anything between those two.
Confident.
Thank you. In light of those questions and answers, we will redirect.
No, redirect, Your Honor.
Thank you. The witness is thanked and excused. Any other witnesses?
Yes, Your Honor, the plaintiff calls Dr. Morgan Judd to the stand.
For all witnesses and attorneys, if we get back here, please notice, I'm sure you have the boards that are covered over here and there, just make it clear. Counsel, witnesses.
Yes, Your Honor. Good afternoon, Dr. Judd. Could you please introduce yourself to the court?
Good afternoon. My name is Dr. Morgan Judd, and I'm an associate professor at the Center for Gun Violence Prevention at Imperial State University School of Public Health. I also hold a PhD in public policy from state.
What is your experience in the field of firearm safety?
Before I started my journey as an academic, I was an officer at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or commonly known as ATF, for nearly a decade. During my time there, I was heavily versed in different kinds of firearms and their safety mechanisms.
How did you become aware of today's case, Dr. Judd?
In January of 2023, I was retained by counsel for the plaintiff, Justice Carbo, regarding this case.
What materials were you provided to complete your analysis?
In order to conduct my analysis, I reviewed the depositions of the plaintiff, Justice Carbo, as well as that of Skylar Pullman, multiple witness affidavits, as well as exhibits 1 to 22.
What methodology did you use in analyzing these documents?
Well, I used these documents to compare the conduct of Shooting Star as well as that of Drew Cantrell to industry standards regarding best firearm practice.
And is this common in the field of firearm safety?
Yes, of course, to determine if violations are committed, it must be compared to the industry standards that exist.
Your Honor, permission to tender Dr. Judd as an expert in the field of firearm safety.
You are tendering Dr. Judd, also, correct?
Yes, Your Honor.
Thank you. Under the rulings issued by the chief judge in our jurisdiction, my understanding is notwithstanding the stipulation we have to take, that we should offer the opportunity to voir dire if you so choose. Do you wish to voir dire the witness?
Your Honor, given the fact that Dr. Morgan Judd has already been tendered as an expert given the pretrial order as well, I have no objection to their tendering, and I will not raise it.
Thank you very much. Doctor is accepted as an expert in firearm safety.
Yes, Your Honor. Dr. Judd, have you encountered any basic guidelines through your work?
Yes, there are typically 5 guidelines that are practically universally followed within my field. I actually got a poster to help me explain these to the jury today.
Your Honor, permission for Dr. Judd to step up to the witness stand to retrieve that poster?
Yes, it hasn't been shared with both accounts.
Yes, Your Honor, this demonstrative has been reviewed.
Very good, thank you.
Your Honor, may Dr. Judd also have permission to mark up the demonstrative during the testimony?
Is your demonstrative?
Yes, Your Honor.
Yes. Yes, please, and if this comes up with other attorneys, the cross-examining attorney may certainly relocate within the courtroom to get a full view of whatever's being demonstrated. Would ask that you not alert directly behind our jurors or scorers. Not that you were, I'm just saying for everyone's benefit, and we'll be set to go.
Yes, Your Honor. Dr. Judd, could you please explain the first couple rules? So the first two rules include keep firearms unloaded, except when not in use. This is to ensure that a loaded gun cannot accidentally misfire. The next one is to ensure to never point the firearm at another person, which is pretty self-explanatory, but if this did happen and a shot were to go off, the individual could be seriously harmed or injured. What are the next couple rules? This is to be aware of the target, including the surroundings of the target itself, as well as the shooter should also be aware of their own surroundings that could potentially impede a safe shot. Additionally, use firearm safety mechanisms correctly, as safety is not a be-all end-all that a shot will not go off. It must be used properly in order to function. What's the last guideline, Dr. This is to never pull the trigger except when firing. Again, to ensure that an accidental misfire does not happen and an individual is not seriously harmed. How important is it to know and follow these 5 guidelines? It's imperative. They're typically the first 5 guidelines taught to new gun users, and a violation of any of them is considered a serious safety hazard. It's like riding a motorcycle without helmet. Does repeating violations impact how serious they are? Yes, of course. If you show a blatant disregard for basic firearm safety on multiple occasions, it should be called into question. But does repeating the same incident matter? Yes, of course. Again, it's even more serious if you violated the same rule over and over again. Dr. Judd, did you notice any violations of conduct in this case? Yes, I noted 2 notable instances when Drew Cantrell violated these particular safety guidelines. One in May of 2021 and one in November. What happened in May of 2021? In May of 2021, Drew Cantrell pointed a firearm at another person in the shop, violating this basic safety rule right here. Never point a firearm at another person. Dr. Judd, what happened in November of 2021? In November of 2021, Drew Cantrell brought a loaded gun back to the shop from the range, violating the first basic guideline listed here: keep firearms unloaded except. Your Honor, permission for Dr. Judd to return to the witness stand.
Certainly.
Dr. Judd, were there any similarities between these instances and the one on May 28th? The same irresponsibility and lack of care showcased by Drew Cantrell in these incidents was seen again on May 28th, when they violated yet another basic gun safety. Dr. Judd, I'd now like to ask about gaining firearms knowledge. How can someone learn how to use a firearm safely? You can go to gun ranges. Many do offer safety instruction courses, but the Imperial government also offers courses that teach basic gun safety. These are mandatory to take if you then want to teach gun safety to another individual. Did Mr. Cantrell take these courses? Yes, they had these certifications. How effective are these courses? They're fairly effective. They teach quite a bit about basic gun safety, but unfortunately, they cannot guarantee it. Why is that so, Dr. Judd? Well, nothing can guarantee firearm safety. Just because an individual understands the rules on one particular day doesn't mean that they'll follow it the next. It's like a food license. If a restaurant receives a grade A health rating on one day, if they do not continue to uphold to the standard, they could easily be downgraded to B. What would happen if an employee demonstrated unsafe firearms use? If an individual demonstrated unsafe firearms use, their employer should take it into consideration. Dr. Judd, I'd like to talk about the safety course that was taught on May 28th. Could you describe the situation that this course was taught under? Well, in my analysis of the case, I learned that Drew Cantrell was only told the morning of the course that they would be teaching it later that day. Additionally, they learned that they would be teaching 2 students, not 1, and that Shooting Star had no standardized way of teaching these courses. Honestly, I was shocked. Why were you shocked, Dr. Judd? Well, informing an individual the morning of a course that they will be teaching later that day doesn't really give them enough time to prepare for it. Even if an individual has used a gun of that particular make and model before, each gun has its own peculiarity that an individual needs to become aware of. Did you identify any safety violations with the instruction of the course?
Yes, I found two main issues with the course itself, being that Drew Cantrell improperly handled the firearm and was unaware of their surroundings.
Why did you conclude that Mr. Cantrell was unaware of his surroundings?
Well, in the fact that they placed Miss Carbo and Miss Allred only feet away from themselves with no divider in between. Part of the basic safety rule of be aware of the target includes being aware of the surroundings that could potentially impede a safe shot from being taken.
So was the safety rule of be aware of your target violated on May 28th?
Yes, absolutely.
Your Honor, permission for Dr. Judd to step off the witness stand once again to mark the demonstrative?
Sure. Again, counsel, find a place to duly proceed. With that,
Yes,
I'm
Your
sorry,
Honor.
counsel, for having to move to that.
Apologies, Your Honor. Dr. Judd, what evidence suggested that Mr. Cantrell improperly used his firearm?
Well, in the fact that they flinched before the first shot was taken. A firm grip is required on the gun at all times. The grip that Cantrell had could have resulted in the second shot being fired.
Was this firearm safety course reflective of proper firearm safety?
Absolutely not. Firearm safety courses are designed to keep people using and interacting with firearms safe. This, of course, violated its very purpose and the fact that Justice Carbo was taken away on the stretcher.
Thank you, Dr. Judd. Thank you, Your Honor. I admit it.
Thank you. Any cross-examination?
Yes, Your Honor, I simply ask that the opposing counsel whether you can start with the answer. Dr. Judge, you charged $400 an hour for your work in your analysis of this case alone.
Yes, I spent 36 hours reviewing the materials that I was provided with for this case and was compensated.
But that's a yes to my question.
Yes, I was.
So that means that in total, for your analysis alone, you charged Justice Fargo $14,400.
Something to that effect.
And for your testimony here in court today, you charge a flat rate of $6,000 plus an additional $600 an hour.
Yes, to travel to the court and to give my testimony here today, I do charge an additional.
But in all your analysis, you never reviewed Ross Hernandez's affidavit.
No, I was not provided with that material.
You didn't even personally interview any of the witnesses.
That's not a part of my job. I merely review the evidence that I'm provided with after interviews have been conducted.
But that's a yes to my question.
No, I do not interview the witnesses.
Thank you. Now, you say that you're concerned with Shooting Star's lack of preparation for the course itself,
Yes, that's correct.
a course which they run on a regular basis.
I'm told that they do run this course on a regular basis, yes, but as I mentioned, each gun has its own peculiarity, even if they're the same make and model that.
Objection, Your Honor, the witness is not responsive. I didn't ask about any variation of gun's behavior.
I will overrule it, but remind the witness to be, to adhere to the question. You can finish your answer.
You need to become aware of the individual peculiarities of the firearm.
And the course is run by Drew Cantrell.
Yes, that's correct.
We've been teaching the course for roughly 9 months at this point.
Yes, but again, you need to become aware of the individual peculiarities.
And now during that course, Drew Cantrell used Justice Carbo's Glock 22,
The one they had purchased.
which you also disapprove of.
Yes, that's correct. Again, they need to be aware of the specific peculiarities of the gun for teaching another person that specific firearm.
Because no two guns behave the same.
Exactly.
So if the training was to have used a different firearm, it would have behaved differently from Carbo's Glock 22.
Objection, Your Honor. On the grounds of speculation.
Your Honor, very sorry.
Your objection is that it calls for the witness to speculate.
Yes, Your Honor. May I elaborate briefly?
Very briefly.
Your Honor, Dr. Judd was asked to create an analysis given the materials in the case, and opposing counsel's question goes outside of the scope of those materials and requires that Dr. Judd speculate to what might have happened if Mr. Cantrell was given a different gun.
Thank you. Response?
Your Honor, the witness has already testified that no two guns behave the same. Each gun behaves differently, just like everybody has different fingerprints. And the witness has already just testified to that, so I'm simply asking them to apply that knowledge and further testified that if the training had used a different firearm, it would have behaved differently from Carbo's Glock 22.
Witness is an expert witness, so I will permit the question and will be fully objective.
Yes, Your Honor.
Thank you. Would you like me to ask the question?
Yes.
So if the training was to use a different firearm, it would have behaved differently from Carbo's Glock 22?
Potentially, but other issues that I had with the safety course may have still resulted.
And so now, in terms of Cantrell's conduct, or in terms of Cantrell's competence to teach the course, you claim that 2 prior mistakes of theirs make them incompetent?
A blatant disregard for the rules on numerous occasions.
By numerous occasions, you mean 2 times?
Yeah, multiple times they violated basic guidelines of gun safety.
But you admit that even experienced firearm users have accidents with firearms?
Yes, and of course, incidents do not make an individual who they are. With proper retraining, they can, of course, overcome these.
But that doesn't make them any less experienced. The fact that even experienced gun owners have incidents with guns does not make them any less experienced.
They can still very safely handle firearms if given the proper recommendation afterwards. Of course.
Now, despite this, you still claim that Cantrell's 2 prior mistakes foreshadowed the events on May 28th.
Yes, as they were not properly reprimanded for the incident.
But these violations were made over the span of a year?
They were made over the span of a couple of months.
Over the span of a year?
Sure. Yes.
Objection, Your Honor. Asked and answered.
And these violations were both 6 months apart from each other?
Yes, a couple of months apart.
And from May 28th, 2022, the most recent mistake was in November of 2021?
Yes, I believe the previous incident that happened was in February.
And Cantrell was reprimanded after both of these incidents?
They received a verbal warning, but other than that, there was no further retraining or anything like that.
Sorry, they were corrected after both of these incidents.
They received a verbal warning, yes.
And Skylar Coleman even issued a formal memorandum threatening termination to Drew Cantrell?
Yes, but nothing to rectify the mistakes and prevent them from happening again.
And neither of these incidents ever involved any customers?
I don't believe so, no.
And they never resulted in any injury?
No, but they don't have to result in injury for them to be serious violations of basic gun safety.
So that's a no to my question?
No, they did not injure anybody.
Thank you. No further questions.
Thank you. Any redirect in light of those questions?
No redirect, Your Honor.
Thank you, Dr. Yu. Thank you for your appearance. You are excused at this time. As per Imperial regulations, I understand the plaintiff rest at this time. We will take no more than 5 minutes, and that's a hard 5 minutes. And unless either side has an objection, and they don't, timekeepers, please start the clock for 5 minutes. Timekeepers, when you get back, begin by asking you guys for the respective side. I don't know much time.
Right there.
And we both agree on whatever. You don't have to.
Thanks. Bye. Where did you go? Yes.
Gosh, you have that.
I've been following you now, but there's no secret.
This summer for a lot. Really? Yes, yes. How's that?
Just one of your, I don't think so. Sure.
Hey everyone, just gonna let you know, we're gonna take a slightly longer break than usual because we need to move some stuff that was in the back. This was our office before round 4. So if y'all wanna like go to the bathroom or like stretch or take a walk, we'll resume in about 10 minutes. That's okay, Chris. Sorry about that. Thank you.
So tell me about yourself.
I'm a undergraduate student at UC. Third year. Planning to go to law school. I do mock trial.
That's went on in high school with UMBC.
Yeah, we went against them last year. Yes, we were very scared of Sylvia. That's awesome. Are you coach?
We first went from a big law firm to a high school teacher. And so we just thought the kids should be given chances, and so I've been the attorney coach, and he's been the teacher coach for the 30 years. He's recently retired.
That's awesome.
Yeah.
That's awesome. Where are you guys from?
And yeah, we were privileged with some very special kids and able to, we took them around to Empire, they got second in the national competition. So, not Sydney, it was after her, but we also took me to report and that was pretty cool.
I like how they do that little pre-trial.
Love the pre-trial.
They don't do that in college.
It doesn't make sense. I mean, that's one of the best things. And
I think so. It really differentiate.
yeah, then you have to kind of train this out and a little bit. So I like that. But what's the problem this year? And is it the one with the monkey? Seems like they always have the monkey.
That's funny. Yeah, it's the chicken change the chicken. Yeah, the chimp face. Yeah, it's like an conspiracy case.
Okay.
They're doing, you can elect on items. They're not coded. You can choose to like prosecute one of the people they robbed or somebody who's but it's a good case. Yeah. We have our first women.
But are you an attorney or are you?
I'm an attorney and expert. I do all the directly experts.
Okay, that's great.
It's a good time. That's so cool. Is your team here this week?
No, sit down retired.
Oh, got it.
And so, and yeah, I want just to, do it individually, so.
What sort of law do you guys do?
Like eminent domain and insurance coverage. They got you Washington station, the train station.
Yeah.
I'm representing and hiring that. They don't own it. We say it's worth 250 million. The other side says it's worth 300 million. So we're fighting.
On the value.
Some NPR's issues, so it's but sometimes can be exhausting. So this was like a nice little weekend away for us.
Yeah, that's great.
Yeah.
Yeah,
So where are you thinking about law school?
I mean, wherever it'll take me, but probably East Coast. I'm on the East Coast. Just not sure. So I'm originally from New Jersey, so I went to even go closer to move.
Yeah, I think depends on what you want to do. I mean, I think everybody needs to go to. It's really important to come out with this little bit. I've seen that too many times people have opportunities restricted because they come out with $100 something behind it. That's really hard, I think. So there's lots of good schools, the whole Philadelphia area. What part of New Jersey are you from?
I'm from the Northeast, so far from Philly.
Okay.
But sort of, right next to like the New York.
Okay. Okay. So what's the town?
Like rock.
Okay.
It's you see on the map?
Yeah.
We have a rock and 10,000 people.
Yeah.
Yeah, I don't know. I'll see where I end up. I probably won't go straight through the
My daughter is here, and she's principal attorney for a very powerful committee. Some
Oh, wow.
she's involved and, you know, if you're human, then what happens? She's always, you know.
That's what, like, it's like political based.
It's like, yeah, so it's like dealing with statutes, how to
Oh,
put together budgets, all that sort of stuff. If we cut this, if you want this, we have to cut that. If we really want to do that.
right. That's cool. That's a cool job. I definitely used to do that.
That's one of, if you may also want to think about, if you like that type of area, let's think about let's see,
Right.
all the law schools and there because it's really.
How close are you guys from like this?
We're about. Chicago,
Oh, yeah.
an hour and a half.
Okay.
Did you do Empire?
I did not. I didn't know about mock trial until I came to, which I think helps in some. I don't know if that helps in some way. My high school didn't have mock trial, but yeah, if they have one, I would.
No, I think the judging is really helpful. I'm thankful my associates to do it, because you can see like the inclusive demonstrators, like.
I went. They did this case in September. And there was the one round I saw. There was a demonstrator that shows like future. And they just like they spent the entire day putting like pointers on it where people are located. Like that thing's that's a good. Oh yeah.
You say,
Oh,
no, can you tell me the person to stand up?
Position in the lab. I don't know why it's the same. They truly can't tell what it should always be. They should like position it.
What's your major?
It's I'm doubling. There's like a pre-law. It's called.
Right, you like micro or macro or?
It's sure of both, right? Mostly it's just like math. Coding.
Okay, I'm thinking about, there's gonna be a lot of. And emphasis, all this sort of stuff. And that's somebody.
I don't think expect AI is not even in the law based. I'm guessing they didn't use it again.
Well, I, you know, it's every minute. I have to just see what it is, and look like keep my finger and what's developing. So I said, okay, LGBT, meet with the derogatories and try to plaintiff and stuff and quality. I'm happy to hear them to what an associate. Yeah. No, I mean, it's complicated, they're not.
There's a recent case where someone had something wrote their closing or some charges. For using
Well, I think it's just a few. I guess think it's just, you know, so.
yeah, it must have been a bad.
If you lose a case for the people, and then that's the author.
Yeah, that's yeah.
I mean, is this like one of the better things or is it,
It's like
All right, guys, let's try to pull together.
Thank you all for your understanding and kindness. Your all loss has been extended by 15 minutes.
One, two, one, third.
I believe the moves, it has yet to return to the bathroom.
Right, we'll continue. In light of the circumstances, we're going to make sure we get the whole trial. No worries. Stuff happens in real life too. Rooms have to be evacuated from terrorists, and everybody has to make the best of it. The folks here at Empire have been issued an extraordinary number of challenges today. They really deserve blue shirts. Everybody deserves our thanks for their patience and perseverance in light of one difficult disaster after another imposed upon them. So just wait. No worries. Attorney Wu, don't feel bad. You were ready to go with everyone when we first took a break, so that's not your fault at all, particularly given the Byzantine way that the rest of the. But we're now all back. So court is back in session. Let me begin by getting a time check. Timekeeper for the plaintiff. How much time is remaining in the plaintiff's presentation?
Your Honor, the plaintiff has 31 minutes and 12 seconds.
Very good. And timekeeper for the defense, how much time is remaining in the defense's presentation?
Your Honor, the defense has 31 minutes and 46 seconds.
Thank you very much. And the timekeepers have professionally conferred and have agreed on both of those. So we're all set to go. Shooting Star Gun Club may present your case at this time. As per the special instructions, you're required to call Drew Cantrell as your first witness. Are you ready to proceed?
Yes, Your Honor. At this time, the defense calls Drew Cantrell to the stand.
Thank you.
Good afternoon.
Good afternoon.
May you state your name and spell your last for the court?
Good evening. My name is Drew Cantrell, Cantrell.
Where do you work?
I work at Shooting Star Gun Club. I'm a safety instructor.
And how long have you been working at Shooting Star?
About 3 years now, I believe. I was first hired in 2020 at the height of the COVID pandemic.
And why did you apply to Shooting Star?
Well, I mean, I originally applied as a sales clerk. I mean, I've been involved with guns recreationally my whole life, and so it seemed like a chance to turn a passionate hobby of mine into a gig.
So what did the application process look like at Shooting Star?
Well, I noticed they had a help wanted sign, so I approached the owner, Skylar Coleman, about any open positions. They said that a clerk position was open, so we sat down for a pretty lengthy interview.
And what happened during this interview?
We talked about my experience handling guns, how I had been, like I said, using them recreationally my whole life. How in my previous job, I managed an auto parts inventory, and so I was qualified to manage the inventory.
Objection, Your Honor, to hearsay.
Your Honor, may I respond?
And which statement?
Well, Your Honor, this witness is testifying to statements that they made during the interview, specifically in regards to how their experience with their previous employment.
So you're objecting to testimony regarding his own statement?
Yes, Your Honor.
Very good. Thank you. Response.
Your Honor, the witness is simply laying foundation for what knowledge Shooting Star had at the time when they hired the witness, and furthermore, they're simply giving context of what was happening during the interview?
Are you offering it for the truth of the matter asserted therein or for other purposes?
No, merely for context of the foundation.
I will overrule the objection.
Yes, Your Honor.
So what happened after the interview?
Well, after the interview, I signed some documents, something that looked to me like a background check. I also provided.
Objection, Your Honor, speculation.
So you could phrase what looked like a background check.
Yes, Your Honor.
Counsel?
Your Honor, the witness is simply testifying to their perception of what they were signing. They are not asserting that it was indeed a background check. They are simply saying that they believe that it was.
Well, counsel?
Yes, Your Honor. We believe that this witness is speculating to the fact that they did in fact complete a background check, and that is not within their knowledge and is speculative.
The extent it is offering, you are offering it to demonstrate that he understood it was a background check. The objection is sustained.
So what happened after the interview?
After the interview, I provided someone with my driver's license. And then a couple weeks later, I got a call back saying that I got the job.
And did you accept the offer?
I did, yes.
So how were the first few months of your job as a sales clerk?
Objection, Your Honor, this calls for narrative.
Overruled.
Would you like me to re-ask the question?
Yes, please.
So how were your first few months as a sales clerk?
Well, they were great. I mean, everything went pretty smoothly. I did exactly what I kind of assumed my job would be. I managed the cash register. I spoke with customers about firearms.
Did you intend on staying a sales clerk?
I didn't know. A little while into my job as a sales clerk, I eventually decided I wanted to be an instructor.
And what did the process to becoming a safety instructor look like?
Well, during my time as a sales clerk, I got a safety certificate, a firearm safety certificate. And so to become an instructor, I then had to get an instructor certificate. So I did that.
And once you received the certificate, did you immediately start as an instructor?
No, not immediately. When I first wanted to become an instructor, there were no positions open, so I had to wait a little while.
And when did you start as an instructor?
I became an instructor in, I believe, August of 2021.
Did everything go according to plan until then?
No, my time as becoming an instructor was a little.
What do you mean by bumpy?
There was an incident in May of 2021, a little bit before I got the instructor position, in which I had been inspecting a handgun, and I guess I had it pointed towards the floor, but Skylar Pullman came in yelling at me to never point a gun at another person, which I was shocked about because I wasn't doing it at all.
But were you still promoted even after this incident?
I was. I mean, I was still doing my job very well, and I got that instructor certificate.
So what did that promotion process look like for you?
Well, like I said, I went to Pullman and they told me that I needed that instructor certificate. So I filled out some forms and eventually got it.
And once you were an instructor, were you involved in any other incidents?
I was, yes, a little bit into my time as an instructor. I had another.
Could you describe this incident?
Well, that one was in November of 2021, I believe. I had been teaching a course at the gun range, kind of how I normally do. And I brought the gun from the range back into the shop and hadn't emptied out the chamber first. I was going to do it at the shop, which is against company policy. We're normally supposed to empty it at the range. It was a mistake on my part, and I'm pretty upset at that, so I never did that again.
So how did Coleman respond to this?
Well, they sat me down, they totally chewed me out for that, and then they wrote me up for it. I got a warning letter.
Now, other than your November incident, how was your performance as a safety instructor?
It was great. I mean, the customers seemed to love me. I was really enjoying my job.
Speculation.
To the customer seemed to love me.
Yes, John.
Counsel?
Your Honor, the witness can testify to their perception of what the customer, whether this customer seemed to like them or not. Furthermore, the witness was informed by several customers that the customers did indeed like them. They received many good reviews. So I believe that the witness can testify to their perception of how they did.
Counsel?
Yes, Your Honor. The opposing counsel has laid sufficient foundation that this witness in fact knows about any customers that have been giving them good reviews. In addition, a statement like the customers seem to love me is outside of this witness's scope of knowledge and what he said.
Overrule the objection, testify to what he says.
Yes, Your Honor.
Would you like me to re-ask the question? So other than the November incident, how was your performance as a safety instructor?
Right, so like I was saying, the customers seemed to really enjoy me and I was really enjoying my job. I mean, I was able to handle firearms the way I had all my life.
When did this customer satisfaction change?
Well, I mean, I did have an incident in May of 2022.
And who was involved in this incident?
Justice Carbo and Nick Allred.
And who is Justice Garbo?
Justice Carbo was a woman that I was teaching a safety course to. She had been wanting to purchase a gun and take a safety course to shoot this gun.
What did you know about Justice Garbo?
Well, I had already been told earlier that I would be teaching this course to Carbo, and I was made aware that they were new to guns and that they would need this this demonstration to help them.
So when did you meet Justice Garbo?
I actually met her in person on May 28th of 2022, but I had already known about it.
And what did Justice Garbo want to do at Shooting Star?
Well, she wanted to purchase a firearm. I think it was for self-defense purposes, and then take a course to learn how to safely use it.
And did they take your safety course?
She did, yeah. She and a man named Nick Allred came and took my safety course.
So what did you do when you where did this course take place?
It just took place in the gun range. I did it at Skull 11.
So what did you do when you entered the range for the course?
Well, I used the Block 22 that Ms. Carbo was going to purchase to do my demonstration, and I brought them into the gun range where I started my demonstration.
What did you do next?
Well, then I gave them the basic safety equipment that they would be needing, and I walked through kind of the basic safety procedures and demonstrated them on the gun as I explained.
What did you demonstrate next?
Then I went into the demonstration on how to actually aim and fire the gun, and that's what things went.
What did you warn Justice Carbo about before demonstrating how to fire the weapon?
Well, before firing the weapon, I warned them that needles often flinch at the recoil, because it can be very simple.
Objection, Your Honor, to hearsay.
Counsel,
Your Honor,
did this statement attributed to him? To don't state that?
Yes, Your Honor, in regards to the fact that new gun owners.
Counsel?
Your Honor, the witness is simply testifying to the broader scope of what they warned their students about, not to specific wording, not to anything specific, and furthermore, this gives context to what came next in the safety course.
Counsel?
Yes, Your Honor, we believe that opposing counsel is using this testimony to state that new gun owners will flinch in anticipation of the recoil in order to further their narrative that Justice Carbo moved during the safety demonstration.
Thank you. I'll overrule the objection.
Yes, Your Honor.
So would you like me to repeat the question?
I think you gave the answer. You may repose.
I believe you may be right, Your Honor. So what happened when you demonstrated how to fire the firearm?
Well, I pointed my gun at the target and I took my first shot, and the recoil was so much stronger than I was expecting. I mean, normally I can absorb a shot like that, but Miss Carbo was standing way too close to me all of a sudden and knocked me to my arm, which caused the gun to fall out of my hand, and that's when the next shot fired.
How many times did you pull the trigger?
I only pulled the trigger once.
Thank you. No further questions. Your Honor.
Thank you. Any further examination?
Yes, Your Honor. May I proceed, Your Honor?
Please.
Good afternoon, Mr. Cantrell. I want to start by talking to you about how you were hired at Shooting Star. You were interviewed by the owner, Skylar Coleman, is that correct?
That's correct.
At that time of the interview, you had just been fired from your previous job at Imperial Engine, is that correct?
That's right. I previously worked at Imperial Engine and I was just so overworking there. I did not enjoy my.
You were fired from that job, is that correct?
That's correct. So I was not upset about
In fact, you were fired for being drunk on the job.
Objection, Your Honor, this is improper character evidence.
Yes, sir.
Well, please, and specifically why is it improper?
Because they're attempting to use, they're attempting to use, instances from, Drew Cantrell's past. Specifically, when they were fired for being accused of being drunk on the job, they were never actually proven of being drunk on the job. It was merely an accusation.
So it's based upon the substance and not any procedural problem. Thank you. Response.
Yes, Your Honor, if I may direct you to a piece of case law in the Patron, which states that character evidence is extremely relevant in case of negligent hiring, supervision, and retention. On behalf of the plaintiff, we are trying to prove to you that this witness, Mr. Cantrell, was reckless, and that is one of the traits in their character that we're looking
Your Honor, sure. According to Imperial Code, if the plaintiff wants to offer evidence, any character evidence, they must do so on the character evidence form before the trial. If I'm not mistaken, I do not recall the plaintiff specifying that they would like to attack Drew Cantrell's former instances of alcohol use.
So that's a procedural check. Sure. Okay. So we'll try to keep them separate. Let's focus for a second on the procedural issue.
Yes, Your
You
Honor.
have a response with that.
Well, Your Honor, on that character evidence form, we have indicated that we intend to offer the trait of recklessness in this witness's character, and we believe that their previous conduct and the reason why they're terminated at their previous employment goes towards that character.
So I'm going to overrule the objection on that basis, given the form I've been provided before trial. Now, would Attorney Wu, can we focus on the, actually, you had already helped me. So let me come back to you. With regard to the substance, is this inappropriate use of character evidence in light of the case Attorney Wu has cited?
Given that case law and given the character evidence form, no, it's not.
So we will overrule the objection in some time. So you may repose the question and
Yes,
we can go from there.
Yes, sir.
Did you have something else?
No, you don't.
Okay, thank you.
Mr. Cantrell, you were fired from your previous job for being drunk on the job, is that correct?
That's what I was fired for. It's not at all what happened, but it's what I was fired for, and I just really didn't feel like fighting it. I kind of just wanted to get out of there anyway.
It's true, Ms. Cantrell, that you also have a criminal record, is that correct?
Unfortunately, yes, it's not something I'm proud of at all.
And you recognize a copy of that criminal record if I were to show it to you?
I would, yes.
Let the record reflect that I'm approaching a person and wishing to approach witness with an exhibit.
Please. What is the exhibit number?
It is exhibit 21, Your Honor. Would you like a copy?
Sure. Thank you.
You recognize that exhibit, right?
I do, yes.
That's a copy of your criminal record, is that correct?
It is.
And it's a true and accurate copy of that criminal record?
Yes, it looks like it.
Your Honor, at this time, we can use to enter this exhibit 21 into evidence.
Any objection?
Yes, Your Honor, here's some.
And now, can you be specific?
Yes, Your Honor, this is an out-of-court statement that the plaintiff is clearly trying to use to prove the truth of the matter asserted, specifically whether Drew Cantrell is competent to be a firearm safety instructor.
Are you offering for the truth?
Well, Your Honor, this witness has already confirmed that this is in fact a true and accurate copy of their criminal record.
Well, that part I understand. It is authentic, but are you offering this? For what purpose are you offering?
Well, Your Honor, for two reasons. First, to again demonstrate the trait of recklessness, as prior bad acts are relevant in today's case. And additionally, this line of questioning that I will be going into will be in reference to Skylar Coleman's questions regarding this criminal background and specifically how that goes towards their lack of due diligence in that regard.
Counsel?
Your Honor, the plaintiff witness has clearly just specified that they will be using this document for the truth of the matter asserted, and if they have failed to respond to my hearsay objection.
Last word.
Your Honor, I did respond to the opposing counsel's argument in that you're not using this for the truth, you're using it to demonstrate recklessness and also to demonstrate that Skylar Coleman did not perform the
Your Honor, may I respond? Sure. The recklessness is a very large part of the alleged negligence, supervision, hiring, and intentions in this case, meaning that the plaintiff is indeed offering this for the truth of the matter.
I'm going to sustain the objection in part when instructed the jury that they may consider this evidence along with any other evidence with regard to the extent to which this employer was negligent in their hiring or supervision of its employee. They may not consider it for any other purpose. To that extent, the objection is sustained.
Yes, Your Honor. And to the extent that it was outlined, the exhibit is entered, just to confirm.
It is entered for the sole purpose of relevant only to the issue of the employer's alleged negligence, supervision, hiring, entrustment issue.
Yes, Your
So
Honor.
you may use it only for that purpose, and counsel may reassert objection if it becomes clear that we have ventured beyond those grounds.
Yes, Your Honor.
Thank you.
Mr. Cantrell, during your interview with Ms. Coleman, they didn't ask you any questions about your criminal background. Is that correct?
No, I mean, I don't really see how it has anything to do with my job at Star.
But to no to my question, Ms. Coleman didn't ask you any questions regarding your criminal background.
No.
Now, I want to move on to your employment at Shooting Star. Now, as you mentioned on direct, you were first hired as a sales clerk. Is that
That's
correct? You're aware of some gun safety rules that are posted around the gun. Is that correct?
Right, we have our gun safety rules in the shop so that to remind customers of our basic rules.
Do you recognize a copy of those rules if I were to show them to you?
I would, yes, definitely.
At the record, I'd like to enter a copy of the debate to the council and permission to approach the witness with this bill.
Yes, please.
You recognize that, right?
Yes.
By that, you refer to Exhibit A.
Yes, Your Honor.
Thank you.
You recognize that exhibit?
I do.
Those are the gun safety rules that are posted in Shooting Star.
Right, these are just some of our basic rules.
And that's a true and accurate copy of those.
Yeah.
Now, at this time, the plaintiff asks moves to enter this exhibit as evidence.
Any objection?
Yes, Your Honor, this document is presented.
Counsel?
Well, I have two responses, Your Honor. Firstly, that there is no inherent truth value to the statements in this exhibit. And secondly, that we are using it not for the truth of its contents, but rather to demonstrate that Mr. Cantrell was aware of these rules and would have conducted their employment in regards to the accordance.
Your Honor, the plaintiff's expert witness, Dr. Morgan Judges, already testified to these rules. The jury already heard that testimony. Furthermore, this document is still an out-of-court statement that is being used to try. It is more prejudicial than it is probative to outline exactly which rules Drew Cantrell violated.
I will overrule the objection. You may proceed.
Yes, Your Honor. Move to have it entered into evidence.
It is received. It is received.
Yes, Your Honor. And permission to set up a demonstrative, which is an enlargement of this exhibit.
Have you shown opposing counsel?
Yes, Your Honor.
Very good. You get counsel.
Now, in November of 2021, you violated one of these rules. Correct?
In November of 2021, I did. The one that says if it's loaded, leave it off the line. It was a mistake.
Right. You took a loaded gun from the gun range back into the shop. Is that correct?
Right. Coleman got so angry at me for that one.
It's true that beyond getting angry at you verbally, you didn't face any more repercussions for your violation. Is that correct?
I mean, I was written up for it. It was put in a memorandum that was sent out to me afterwards. It told me that I was kind of going to be watched from then on.
You weren't supervised for any length of time after. Is that correct?
I don't really know what you mean.
Ms. Coleman didn't increase supervision of your work after you violated this rule.
No, I mean, it wasn't really necessary.
They also didn't retrain you. Is that correct?
No, I was still doing my job well, and I had always been doing it well.
They didn't suspend you either, is that correct?
No.
Now, I want to talk to you about the May 28th accident. Now, you led the safety training course in stall 11, is that correct?
That's correct.
And you positioned 2 customers before starting your demonstration, is that correct?
Yes.
You positioned Miss Allred to your right, is that correct?
Yeah, I positioned Miss Allred to my right and then Miss Carbo directly to my right.
Well, just to be clear, Miss Carver was behind you to your right, is that correct?
Right, kind of behind me and to my right, but it was, to make this clear, it was Miss Allred and then Miss Carbo and then me.
Right, and in that position, it's true that you couldn't see Miss Carbo in your peripheral vision in facing the target, is that correct?
Well, I mean, when I was facing the target, I wanted to be clear of the target, so no, not really.
Well, it's true that in the position that you put Miss Allred in, you could see them in your peripheral vision on facing the target, correct?
I could see them better than Miss Carbo, I suppose.
So just to clarify, you couldn't see Miss Carbo in your peripheral vision in the position that you placed them in.
Well, not when I was looking at the target.
I also want to talk about what you did before and leading up to the demonstration. Now, I'm going to read from one of these points, and it's the third last point. Check your weapon.
Objection, Your Honor, this is unnecessarily cumulative. This document has already been entered into evidence. The jury can review it in their deliberations. There is no need to read it aloud for the court.
I'm going to read from the third last bullet. Check your weapon. Always make sure your weapon is functioning correctly, properly cleaned, and safe to use. Did I read that correctly?
Yes.
Now, you mentioned on direct that when you fired the Glock 22 on May 28th, it had an unusually strong recoil, right?
That's correct.
It's true that before the May 28th incident, you didn't check your weapon, right?
I mean, I've used Glock 22s in the past, so I mean, it was very out of the ordinary that this particular Glock 22 was like.
I appreciate that, Mr. Cantor, but that wasn't my question. Before demonstrating with the May 28th handgun, you didn't check that weapon, is that correct?
I didn't do, a full inspection of this gun right before and now.
You didn't check if there were any mechanical errors, is that correct?
No,
You didn't check if it was safe to use, is that correct?
I assumed it would be safe to use. I mean, like at Shooting Star, we make sure all our guns are safe to use.
So just to be clear, you assumed that this gun was safe to use,
Yes,
but you never checked the weapon, is that
I
correct?
didn't, inspect it. If that's what
You didn't practice with it before doing it in front of customers?
No, I've used Glock 22s in the past. I knew what I was getting into.
That particular Glock 22, you didn't practice, is that correct?
Not that particular one. I picked it up because it was one that Carbo was going to be shooting on. So I wanted her to be prepared to use that particular gun.
Well, you'd agree that Ms. Carbo being prepared to use that gun has nothing to do with you checking your weapon, right?
No, I guess not.
Thank you, Ms. Cantro.
Thank you. Counsel, would you like the demonstrator to take it down? Yes. That, very good. And in light of those questions and answers, can you redirect? Yes, please.
Were you actually drinking on the job in your former job?
No, absolutely not. I would never do something like that. I just didn't fight it because I didn't enjoy my job.
Thank you. No further questions.
Thank you. In light of that question and answer, is there any recross?
No recross, Your Honor.
Sir, you are excused and thank please avoid the board. Can I just get a quick time check? What is the time remaining in the plaintiff's case? Excuse me, the defense's case with two more witnesses and a closing argument.
Your Honor, just a moment.
Yes, please.
Your Honor, the plaintiff has 23 minutes and 5 seconds.
3 minutes, and the defense, how much time remaining?
The defense has 23 minutes, 36 seconds.
Thank you very much. I'm just going to need 1 second to figure out. Thank you for, George. Thank you for everyone's indulgence. You wiped out my previous school. That group, I had to go back and put them in very brief comments. I'm sure my colleagues would have would have picked up on everything I would have had. But thank you for your time. We gave the time. Do you have any other witnesses?
Yes, Your Honor, the defense would like to call Avery Wine to the stand. Good evening, Mr. Nguyen. Please state your name, spelling your last name.
Hi, my name is Avery Nguyen, Nguyen.
Where do you live?
I hail from the mainland United States, and now reside in the Union after finishing education.
Where did you go to school?
I got my bachelor's degree in Georgia Tech.
Now, moving back a little, why did you relocate to Missouri?
Well, my work requires that I communicate with both European and East Coast companies, and appearance time zone fits perfectly with my schedule.
Now, Mr. Nguyen, do you have any hobbies?
Yes, I consider myself an enthusiast. I like shooting, hunting, firearm modification, and collecting.
Since you're so into shooting and firearms, do you know anything about Shooting Star Gun Club here in Sweden?
Oh, I am very familiar with them. Shooting Star Gun Club is where I purchased my first firearm ever since moving to Imperium. And it's where I'm constantly my closest friends, and it's also where I'm grounding myself in the community.
Now, what sort of safety precautions have you seen at Shooting Star during the pandemic?
Well, back in around 2008, when Poland took over, they hired personnel and range safety officers who are more proactive and more knowledgeable in firearm safety.
What specifically have you seen with range safety officers during the range of safe environment?
They remind and enforce the rules, such as keeping your finger off the trigger when not using fire. And whenever a customer violates one of these main safety rules, a Shooting Star employee is always right there to correct it. It also is well trained.
Now, let's move on to the incident. Where were you on May 28th, 2022?
As per usual, I was in the shooting range at Shooting Star Gun Club.
Basically, which stall were you at?
I was at the back table behind my counter, stall 3.
And which stall was the training course?
At stall 11.
Now, Mr. Nguyen, if I were to show you a copy of the layout of Shooting Star Gun Club and Courtroom, would you be able to identify your location?
Of course.
Let the record reflect that I am showing the public counsel when it's been marked as exhibit 5A for identification. Permission to approach the witness to see evidence.
Please.
Would your honor like the courtesy copy?
Please.
Do you recognize this document?
Yes, this is a layout of Shooting Star Gun Club.
Is it a fair, accurate representation of Shooting Star Gun Club's layout?
Yes.
Permission to tender to the bench?
Are you introducing it as evidence?
Yes, Your Honor.
Any objection?
No objections, Your Honor.
Thank you. 5A is received. Thank you.
Now, Mr. Nguyen, can you please show the jury where you were located at the time of training?
Well, I was at the back table behind my stall. Stall 3.
Let the record reflect that the witness is pointing into the region directly behind stall 3. Now, Mr. Nguyen, where did the training course take place?
Right here behind stall 11.
Let the record reflect that the witness is pointing at stall 11. Now, at the time of the incident, was there anyone in the stalls between you and stall 11?
No.
Was anything obstructing your vision?
No, my view was unobstructed.
Thank you. Permission to publish 5A to the jury?
Certainly.
Thank you. Let the record reflect that I am now showing the closing counsel of the exhibit 2G grading. Permission to approach the witness?
Yes.
Would your honor like the courtesy copy?
Please, thank you.
Do you recognize this document?
Yes, this is a picture of stall 11 where the incident occurred. However, it has X's on it.
Is it fair, accurate representation of stall 11?
Yes, I would say so.
Permission to enter this document into evidence?
Any objection?
Yes, Your Honor. I'm going to object to lack of foundation. The opposing counsel has provided us with no explanation for how those X's got there, and if it's completely accurate, the witness isn't able to testify to that.
I think, if you wish to respond.
Yes, Your Honor, the witness has testified that they are very familiar with Shooting Star Gun Club, therefore can testify that this is an accurate representation of it. They're simply observing that their ex is not.
I will sustain the objection, given the lack of foundation for the marking on it. You are free to develop foundation and then ask for reintroducing it.
Yes, Your Honor.
Yes.
And what do the exes represent?
Well, it seems to represent where jury control just occurred and they all were standing at around the time of the incident.
Thank you. Permission to now, and there's exhibit 2 seconds.
Any objection?
Yes, Your Honor, I'm still going to object to lack of foundation. We still don't know how the exes got there.
I'm going to overrule that objection, but you're certainly welcome to develop that in cross if you believe it to be further.
Yes, Your Honor.
Now, Mr. Nguyen, when you were watching the, can I now,
Thank you, counsel. That was my mistake. 2G is admitted.
okay, thank you. Now, Mr. Nguyen, where was Drew Cantrell located during the time of the training class?
Well, while I was watching during the incident, I saw that jury control was located closest to me, directly behind stall 11.
Let the record reflect the witness is pointing to the leftmost arrow, X. And now where will Justice Harlow stand?
Justice Carlo stood immediately behind and to the right of jury control.
Let the record reflect that the witness is pointing to the middle X. Now, finally, Mr. Nguyen, where was Nick Allred standing?
Well, I think Allred stood furthest from me at stall 12.
Let the record reflect the witness is pointing to the right X. Permission to publish to the jury. Now, Mr. Nguyen, what did you notice about how these people were?
Well, it seemed as though Justice Carlo was crowding control, which was quite odd.
Thank you. Now, what did you see happen during the training course?
I watched Drew Control aim the gun and fire the first shot, where Justice Carlo jumped and bumped into Control, causing Control's arm to move.
And what happened next?
Well, after Justice Carlo bumped into Control, both the gun and Justice Carlo fell at around the same time the second shot fired.
Thank you. No further questions, Your Honor.
Thank you. Any cross examination?
Yes, Your Honor.
Good evening.
Good afternoon, Mr. Nguyen. Now, you've purchased a collection of guns from Shooting Star.
That is correct.
And almost every time you purchase a gun, you're offered a complimentary safety kit.
Yes, the store clerk usually offers me my complimentary course after every purchase. It's a little annoying at times.
However, you're not actually offered this after every purchase because when Skylar Coleman is the one selling you firearms, you're not offered it, correct?
Well, at times, Skylar Coleman did not offer me the safety course, but I'm no novice with firearms. I could probably teach it to you.
So regardless of your experience with firearms, Skylar Coleman did not offer you his complimentary safety kit.
Yes, at times, Skylar Coleman did not offer me safety course.
Let's talk about your experience at Shooting Star. Now, you mentioned on direct that you've been a part of the Shooting Star community for a long time.
Yes.
You describe it as the second home to you.
Yeah.
In fact, you're there, you even have your own area named after you.
I find it quite endearing.
And you're there so often that you've witnessed several violations of gun safety.
Yes. Nothing major usually.
But in May of 2021, you witnessed the employee Drew Cantrell point a handgun at another person, correct?
I'm not exactly sure what led up to the situation. I was in the shooting range coming into the shop.
So that's a yes to my question. You did witness this?
I'm sorry, could you repeat the question?
You witnessed Drew Cantrell point a handgun at another person, correct?
Well, I clearly witnessed Drew Control pointing the gun. I did not explicitly witness Drew Control pointing the gun at another person. However, I do know of the incident you are currently referencing.
So it's your testimony that you did not witness Drew Cantrell point a handgun at another person?
I explicitly did not witness Drew Control pointing a handgun at another person. I'm not sure where he was pointing it at the time.
All right, I'd like to talk about your experience at Shooting Star, or I'd like to talk about your experience on May 28th. Your Honor,
Let the record reflect that I am showing opposing counsel upon the exhibit.
And the exhibit number is?
Permission to approach the witness with this exhibit?
Yes.
Would Your Honor like to copy that?
Please, thank you.
You recognize this exhibit, correct?
Yes.
This is a photo of the stalls in the gun range.
Yes, however. Yeah,
And this is a true and accurate copy to the best of your knowledge?
indeed it is.
Permission, Your Honor, the plaintiff moves to this exhibit.
Any objection?
No objection, Your Honor.
2F is admitted.
Permission to publish the video.
Please.
Now, before I go on to my next line of questioning, I'd like to go back to that previous question about you never witnessing Drew Canfield point a hand at.
Yes, it should be line 76 on the affidavit.
So you never witnessed Drew Canfield point that your sworn testimony is that you never witnessed Drew Canfield point a hand at the person.
This is correct. I did not explicitly see this or state it in my affidavit.
Now, you remember writing an affidavit for this case, correct?
Yes,
And you were swearing to tell the whole truth?
the whole truth.
You had up until today to edit this affidavit, correct?
Yes, and I was aware of knowledge.
Your Honor, permission to approve the living counsel and the witness, with a copy of their affidavit?
Yes, you don't need permission to approach opposing counsel, but yes, you need permission to approach the witness.
This is a copy of your affidavit, correct?
Yes,
And this is your signature at the back?
yes,
Now, I'm going to read from line,
And counsel, perhaps we could borrow the other copy so that he could read it, without having to read over your shoulder. So
oh,
just
yes, Your Honor.
thank you.
thank you.
So,
I interrupted your question and I apologize. You could perhaps start again so we can catch up with this back.
yes, of course. If you could go to page 4 of your affidavit. I'm going to read from line 72 to 73. The employee was Drew Cantrell, and it actually happened in the shop, not in the range. Cantrell pointed a handgun at another person in the shop, which caused a big commotion. Did I read that correctly?
Yes, you did.
Now, let's talk about the incident on May 28th. If you could go back to your exhibit, to that.
Oh, okay.
So on May 28th, the safety course occurred in the gun range, correct?
Yes,
And a few minutes after the proof started, you saw Drew Cantrell aim the gun towards the range.
yes,
But you just saw this out of the corner of your eye, correct?
yes,
And it looked like Justice Carville was standing very close to Drew Cantrell, as stated on the record.
it seemed as though he was crowding the town.
And then you heard 2 shots,
Yes,
and you saw Justice Carville fall to the floor.
I saw all these events, yeah.
So just to clarify, the safety course occurred in stall 11, second last stall.
Yes,
You were in stall 3.
well, I was at the back, yeah, I was at the back, behind my counter, but yes,
Which was about 30 feet away.
around 30 feet, yes.
So you didn't have the best view of what was happening.
Yes, I cannot say I had the best feel of what's happening as I was 30 feet away. However, I witnessed all the events.
So it's your sworn testimony that you witnessed every single event at the safety course?
I witnessed all the events that occurred during the safety course.
Your Honor, permission to approach the witness again with their affidavit?
They have it still up there, correct?
Yes,
All right, so you can leave his affidavit, that copy. You have an additional one, correct?
I'm going to read on from page 5, line 108 to 109.
yes,
The gun looked like it fell right around the same time the second shot was fired, but I can't say if it was before or after the second shot fired. Again, I wasn't watching very closely. Did I read that correctly?
yes, you did.
So Just to clarify, Mr. Nguyen, you do not know if Justice Carbo moved before the first shot was fired, correct?
I'm sorry, could you repeat the question?
You do not know if Justice Carbo moved before the first shot was fired.
Well, I do know that Justice Carlo jumped. Wait, moved before the first shot was fired?
Yes.
No, I did not witness that happen.
And you do not know for certain if Justice Carbo jumped after the first shot.
I think that Justice Carlo jumped after the first shot. That is what I witnessed.
Just to be clear, that is what you think you saw. You do not know this for 100%.
That is what I witnessed.
So that's a yes to my question.
Yes,
And you do not know exactly when the gun fell to the floor.
I do not know exactly when the gun fell before.
And you were not watching all of Drew Cantrell's movements during the demonstration.
I can say that I was watching all of your controls movements during the demonstration.
Every single one of Drew Cantrell's movements.
Yeah. I was not watching very closely. However, I still witnessed all the events that transpired during the safety.
Thank you, Mr. Nguyen. No further.
Any redirect? Sorry?
Not recently.
All right. Thank you, sir, you were excused and thanked. Before we get our next witness, please be careful with the thing. I get a time check for both sides.
I'm going to calculate your
Just really quick. See to remember one thing. What I've already been. This is the moment just. Okay. All right, time check for the plan.
Yes, Your Honor, play it past 15 minutes and 48 seconds.
Okay.
And then also 17 minutes and 49 seconds.
The presentation of one witness and closing argument. We're set to go. I will alert everyone that through the magic of our technology, perhaps my fumbling fingers, and then again, the last writing I've done with the various attorneys and witnesses. So in order to keep the trial moving, I'm just going to re-enter my scores. I confirm my scores are the same as they were before, but I'm going to depend upon my jurors for more extensive comments, and I, of course, would be glad to stay afterwards if anyone has any other questions. Next witness.
The defense calls Officer Jefferson.
Thank you, officer. Please.
Could you please state your name, spelling your last name for it?
I am Officer Jackie Stone. That's to a
What do you do for work?
I am self-employed at my own firm, Summers LLC, where I work as a firearm.
Where did you receive your education?
I received my bachelor's of science in physics at the U.S. Military Academy at West Point with a minor in economics.
Were you commissioned in the U.S. Army after graduating?
I was. I served in the Army for 7 years as an artillery officer, where I was also qualified as an expert pistol shot.
What special certificates?
I have firearm safety certification with the Imperial Department of Justice, as well as with the U.S. Bureau of Alcohol, Tobacco, Firearms and Explosives.
At this time, I would like to remind the court of Trial Order 13, which states that Jackie Staub meets the threshold for an expert in firearm mechanics and thus can give expert testimony.
So are you tendering for as an expert in that subject at this time?
Yes.
Thank you. Please remain there. Again, pursuant to the Chief Judge's instruction, we are to offer your opposition a chance of voir dire. Would you like to voir dire?
No, I would not.
And do you have any objection to the expert being received in firearm mechanics?
No objections, Your Honor.
Then she shall be received. The witness is back with you.
What was asked of you in this case?
I was asked to provide my expert opinion on whether Drew Control followed industry standards and best practices when handling the firearm on May 28th of 2022.
What materials did you receive in order to give this expert opinion?
I received the affidavits and depositions of 5 witnesses, as well as exhibits 1 through 32.
Are you familiar with the Glock 22 used in this case?
I am familiar with the book.
Your Honor, permission to retrieve exhibit 1 from the bench.
Yes.
Your Honor, at this time, I would like to remind the court of stipulation 1, which states that exhibit 1, the Glock 22, will be admitted in its entirety into evidence.
And it is admitted.
Yes.
Thank you.
Your Honor, permission to approach the witness.
Yeah.
What did I just do?
This would be the Glock 22 used in this case.
How did this Glock 22 change this case?
This was the firearm purchased by Justice Carbo and used by Drew.
What are the parts of this firearm?
The way that this firearm is labeled, this would be the handle of the firearm. Inside contains the magazine. Inside of the magazine contains the cartridges. This would be the barrel of the firearm, in fact, here is the firing. And this is the trigger, which triggers the firing the firing pin and launches the cartridge out of the barrel of the firearm.
Is there anything special about this particular firearm?
This particular model is known as a white trigger, meaning that the force necessary to pull the trigger would be less than that of other firearms.
What is the best practice for holding a firearm?
The best practice for holding a firearm is with a firm and steady.
What can happen if this practice is not followed?
When this practice isn't followed, the recoil of the firearm may cause the operator to lose grip of the firearm, causing it to slip, taking the trajectory of the fired round.
Your Honor, permission to retrieve the other.
Retrieve exhibit 1?
Yeah.
Sure.
Your Honor, permission to retrieve the other.
Okay.
What did you first analyze in this?
I determined whether Drew's Control followed industry standards and best practices when handling the firearm on May 28th, 2022.
To a reasonable degree of scientific certainty, in your expert opinion, did Drew Cantrell safely handle the Glock 22 on May 28th, 2022?
According to my findings, I believe that he did. Based on the fact that, like I mentioned before, the particular model had a trigger, meaning that the force necessary to pull the trigger would be less than that of the firearms, meaning that the recoil of the firearm most likely caused the barrel to repress the firearm, causing that second shot.
Objection, Your Honor. Lack of foundation, Your Honor.
In what way?
Well, the witness failed to provide any foundation as to how she came to that particular conclusion based on what the first counsel asked.
Counsel?
I'm sorry, I think I'm a little bit confused on the question. Could you please repeat? Your Honor, I will respond if you wish.
We're confused about the objection
Yes.
or your question.
No, the objection.
All right. She has objected to a lack of foundation for this expert's opinion. That you have not developed, her contention, you have not developed sufficient background for this expert to render the opinion of the cause of this incident. Have you done so?
I believe so.
And tell me why.
I described that Jack and Stop is an expert in firearm mechanics, thus can describe their expert opinion in this matter.
Very good.
Your Honor, Jackie Staub hasn't specifically stated any documents that she reviewed in order to come to this testimony. And previously in her testimony, she did generally state them, but not anything specific that might lead to this conclusion.
May I respond?
With respect, not at this time, I'm going to overrule the objection. You're certainly welcome to review it later or other circumstances that compel it. And certainly to develop a cross-examination your understanding as to your lack of foundation.
Yes,
It
Your
is
Honor.
overruled. I believe we have the witness examiner. Was there additional information you wanted, or we are ready for him?
We are ready for it.
Very good. Go ahead.
What did you analyze next in this case?
I then analyzed whether True Control flinched prior to shooting the first shot.
By a reasonable degree of scientific certainty and your expert opinion, did Drew Cantrell flinch when holding the firearm on May 28th?
According to my findings, I do not believe that True Control flinched. I believe it is due to the recoil of the firearm and the lead trigger that caused Control to repress the firearm, not due to him flinching that caused that second shot.
Did you make any other analyses regarding the claims brought forth by the plaintiff?
Whether shooting star was negligent for having retained True Control, I do not believe this is so.
Objection, Your Honor.
Brown,
Outside of the scope of the witness's expertise.
counsel. My ears still working. Is there any other opinions you have to render? And I believe her testimony was that there were any others. Am I wrong on that? Isn't that the testimony we just heard?
No.
Okay, then please, what was the last question and last answer?
I asked whether they made any other analyses regarding the claims brought forth by the.
Okay, your answer was what?
My answer was that whether shooting star was negligent in having retained and fired.
You have an opinion on
Yes.
it? Okay. Your contention is that it lacks adequate foundation?
No, Your Honor, my contention is that given that Ms. Staub has been tendered as an expert in firearms mechanics, it is outside of her scope to testify to whether or not Shooting Star negligently retained Drew Cantrell.
Very good. Is this outside the scope of firearm mechanics?
No, Your Honor, I do not believe this is outside the scope.
Tell me why.
Because in order to review in order to give an expert testimony on firearm mechanics, they were asked to review all of the evidence given in this case and thus have the expert knowledge of everything given in this case.
I'm going to sustain the objection to the question as posed. You are free to pose another question that might more directly implicate the first stated expertise.
Yes, Your Honor.
What did you analyze next in this matter?
I then analyzed. I'm sorry, I didn't analyze anything else after that.
No further questions, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. May I proceed?
Yes, please.
Good evening, Ms. Staub.
Good evening.
You examined the block 22 that was used by Mr. Kendra, right?
I did.
You determined that it had a light trigger, right?
I did determine this, yes.
If someone had checked that weapon, they would also determine that it had a light trigger, right?
This would be true, yes.
I'd like to talk to you about your analysis of the incident. You believe the second shot was not caused by Mr. Cantrell flinching, right?
I do believe this, yes.
It's your opinion that if Mr. Cantrell had flinched, the direction of the gun would have changed, right?
Yes.
That the shot would have hit something other than the target, right, Ms. Staub?
Yes, this would be true.
You based this on Mr. Nguyen's account of the incident, right?
Yes, I did.
He didn't observe any movement from Mr. Cantrell.
He did not.
This was despite the directly contradictory evidence from two other witnesses, right, Ms. Staub?
Yes, but I came to this conclusion due to the fact that the two other witnesses were in fact novices on gun safety skills.
You'd agree that advanced firearms knowledge is not required to observe movement from another person, right, Ms. Staub?
Possibly, yeah.
That's a yes to my question?
Possibly.
So, Justice Carbo and Nick Allred were being taught the safety course install a weapon, right?
This is true.
They had a direct view of Mr. Cantrell.
They did.
They were within mere feet of Mr. Cantrell.
They were.
They were watching intently as Mr. Cantrell demonstrated how to use the firearm, right?
This is true, yes.
Mr. Nguyen was at the other end of the range, correct?
They were, yes.
He was behind stall 3.
This is true, yes.
That was about 30 feet away, right, Ms. Staub?
That was, yes.
Mr. Nguyen was in the range for a separate purpose, right?
He was, yes.
In fact, you were aware that Mr. Nguyen was there to customize his rifle.
I am aware of this, yes.
So just to clarify, Mr. Nguyen wasn't paying full attention to the safety demonstration, right?
He was not paying full attention. He did still take note of what happened on the
Just to be clear, you weren't in the shooting range on May 28th, right?
I was not.
So you can say for certain what actually happened, right?
Not me personally, no.
Thank you, Ms. Staub. Thank you, Your Honor. I have no further questions.
Thank you. Any redirect?
Briefly, Your Honor.
Why did you use the affidavit of a renewed in coming to your conclusions about Drew Cantrell on May 28th, 2023?
I did this because Avery Lynn had much more prior experience to using firearms safely. So I believe that he would have known or noticed if something unusual may have happened.
Why didn't you use the testament of Justice Carbo and Nick Allred?
They were novices. That was the first time that they were ever using or learning anything about firearms.
No further questions.
Thank you. In light of those questions and answers, thank you both.
No recross, Your Honor.
Thank you. The witnesses thanked and excused and more to be careful of the who's there. As per Imperial regulations, I understand the defense rests the case at this time. We've been here a while and you guys have other things to do today. And we survived with just a 3-minute break. I hear no objection to that, so we're going to do that. You can think a 3-minute break, all the arguments. Timekeepers, set the clock for 3 minutes and be ready in 2 minutes to tell us how much time everybody has. Get on your mark, get set, go. Yes. Yes, I tell you what I'm going to do. I'm sensitive to anyone lurking behind on a jury. So what I'm thinking, I'm going to offer both of the timekeepers the opportunity to do is to sit here. And that will be it as a your person. Are you for the plaintiff? Yes. Why don't we get you seated right now? So they were set to go, it's you got your stuff, okay, you got your time, right? And you just want to copy. Very good. All right, so we're gonna get your set there. Each one to the defense counsels really briefly. Defense counsel. Okay. Opposing counsel has asked for the opportunity to place a timekeeper somewhere where they can see them. And I think our best place is to put them there in the meeting. If that's okay with you. So when it comes time, you can just slide into that seat. Both of these timekeepers are very professional. Honestly, I think you can do quite well. I'm sure you're comfortable. And you have the time ready to go. Very good. Who is doing the closing? Okay, and so, he told you where he's going to be and everything. Very good. I guess. Absolutely. Why don't we, I would ask that you relocated that there, not behind the jury. Right, and so now you compare this here to the jury and then perhaps you can say. So remain seated until the moment you can get that. Yes, unfortunately, we're missing a drummer, so we're going to. And so. That's going to relocate now, so we're just ready to go right to the jump. Whatever you need to. You know, I'm going to just ask you to stand back in that corner there. Are you okay with him standing there? Yes, John. Okay, very good. Court is back in session. How much time does the plaintiff have for the remainder of the case?
Your Honor, the plaintiff has 13 minutes and 19 seconds.
Thank you. How much time does the defense have for the remainder of the case?
The defense has 11 minutes.
Thank you. For the benefit of jury members, the timekeeper is going to be here. The plaintiff's counsel has alerted us that she intends to use demonstratives, so the defense counsel is going to stand there, but is not going to venture into more protected area. In this jurisdiction, the plaintiff presents its closing argument first. Counsel for Justice Carbo, how much, if any, time would you like to reserve for rebuttal?
Your Honor, I just ask that any time that I don't use my main argument be used for rebuttal.
All remaining time, it is noted.
Yes, Your Honor.
You may proceed when you are ready.
Yes, Your Honor.
For jury members, I've also given them permission in the absence of another case we can do to human. That's something I gave permission.
May I proceed, Your Honor?
Please.
Your Honor, opposing counsel, members of the jury, may I please? The last thing that Justice Carbo expected on May 28th of 2022 was to get shot in the leg by the employee that was meant to be teaching her safety. Now, at a gun range, industry standards should be followed at all times. And customers' safety should be the top priority. Any employee that is using firearms around customers every day should be trained to do so. Today, the plaintiff brought forward one cause of action, and that's the negligent hiring, supervision, or retention of Drew Cantrell by Shooting Star Gun Club. In order to prove this cause of action, we have to prove to you 3 separate facts. The first that Drew Cantrell was unfit to perform their work as a firearm safety instructor. Second, that Shooting Star and Skylar Coleman, the owner of Shooting Star, knew about their unfitness. And third, that their negligent hiring, supervision, and retention of Drew Cantrell approximately caused the May 28th accident. Members of the jury, we have to prove to you these 3 facts by a preponderance of the evidence. That means a hair above 50%. So let's talk about the evidence that we've shown you today. Today we called Dr. Morgan Judd to the stand. She was an expert in firearms safety. She told you about 5 basic safety rules that are industry standard in the field. You can see these 5 rules here. She talked about how throughout Drew Cantrell's employment and on May 28th, Drew Cantrell violated these basic gun safety rules. So let's talk about how they were unfit. In May of 2021, you heard that Drew Cantrell pointed a firearm at another employee. Now, Drew Cantrell denied this fact, but members of the jury, you heard Ross Hernandez, who witnessed the incident, testify to it. And you also heard defense's own witness, Avery Nguyen, testify to it. Members of the jury, Avery Nguyen tried to lie about it, but we brought their affidavit to them, and they, in their affidavit, said that they saw Drew Cantrell point the gun at another person. You also heard about another incident in November of 2021. In that incident, Drew Cantrell brought a loaded firearm from the gun range back to the shop. So now we're at 2 violations. First, never point a firearm at another person. That was violated in May. And then the second, keep firearms unloaded when not in use. That happened and was violated in November 2020. Now, let's move on to the second fact. That Shooting Star knew or ought to have known that Drew Cantrell was unfit as an employee. You heard on cross that in the interview that Drew Cantrell had with Skylar Coleman before getting hired, they weren't asked a single question about their previous employment. They had just been fired from their previous job. Ms. Coleman didn't ask them a single question about it. Not only that, your members of the jury, Ms. Cantrell has a criminal record. They've been convicted of offenses in the past. And Ms. Coleman didn't ask them about their criminal background before hiring them to work at a gun range, where they would be near customers and operating weapons every day. You heard that after the May and November 2021 incidents, Ms. Coleman reprimanded Ms. Cantrell. You heard that that was all they did. After they had violated these fundamental gun safety rules, Ms. Cantrell wasn't supervised for any length of time afterwards. They weren't put on probation. They weren't suspended. They just got a verbal warning. Members of the jury, that is not enough at a gun range. Perhaps throughout this trial, you've tried to put yourself in Ms. Cantrell's shoes. Maybe you could even see yourself making similar mistakes, to see them as a human. For members of the jury, recall that you are not the standard we are holding Ms. Cantrell to. As a firearm safety instructor who uses weapons in front of customers every day, the standard for competence must be high. Because we're not talking about something trivial here, members of the jury. We're not talking about someone getting the wrong order. We're talking about mistakes that could cost people their lives. I want to move on to the third fact, that Shooting Star's negligent hiring, supervision, and retention of Drew Cantrell was the direct cause of the May 28th accident. Now, first of all, you heard from Drew Cantrell on cross that they were aware of the gun range safety rules in Shooting Star. That one of these rules was check your weapon. Always make sure your weapon is functioning correctly, properly cleaned, and safe to use. They were aware that that rule existed. You heard that on May 28th, they experienced an unusually strong recoil that they couldn't control. You heard that they didn't check their weapon before using it in simple demonstration. And you heard from the defense's expert on cross that if Ms. Cantrell would have tested the gun, she would have known about that recoil. But she didn't. She violated company policy, and as a result, she put Ms. Carbo in danger. Members of the jury, if it wasn't Ms. Carbo, it would have been somebody else. Because Ms. Cantrell was an unfit employee, and instead of restricting their ability to continually use guns unsafely around people, Ms. Coleman increased it. They allowed it. And they didn't make sure that Ms. Cantrell complied to these industry standards. Members of the jury, I anticipate that in a moment here, defense counsel will get up here and tell you that improvement is not incompetence. Members of the jury, what we're seeing here isn't improvement. What we're seeing here is an employee who continuously violated gun safety rules over and over again, was never reprimanded for it, and their access to guns grew throughout their employment. That is not improvement, members of the jury. That is incompetence. And that is negligent supervision or retention by Shooting Star Gun Club. I want to take a moment to address the testimony of one of defense witnesses. Now, they called Avery Nguyen to the stand. And Avery Nguyen, he testified to, he saw Carbo crowding Cantrell on May 20th. You heard that they didn't have the best view of what was happening. They were in stall 3. The demonstration was in stall 11. Members of the jury, that is a whole 30 feet away. And that's about the distance between your table and me when I stand here. Members of the jury, have you been paying attention to everything that has been happening on this side of the room throughout today's trial? No, because you've been occupied with your own things. You've been taking notes, you've been listening to testimony, you're listening to my statement right now. There's no reason for you to prioritize what you're doing over watching that side of the room. Members of the jury, that is exactly what was happening on May 28th of this meeting. You heard that he was working on customizations on his own gun. He had no reason to prioritize watching someone else's safety demonstration for what he was doing. Because of that, his testimony isn't reliable. Members of the jury, at a gun range, there's the expectation that people are kept safe. It's not on the customers to ensure that that is happening. It's on the employees, and it's on the employee's employer to make sure that that is happening. It wasn't within Ms. Carbo's knowledge to know what was safe for her on that day. She had never stepped foot into a gun range. She had never even held a gun before. Ms. Cantrell, that was her job. We ask that you find Shooting Star Gun Club liable. Thank you.
Thank you. Shooting Star Gun Club may proceed when you are ready. Do you want any demonstratives?
No, thank you. I'd like to request some demonstrations.
They will. And counsel, if you wish to watch from there, but it's not going to use any demonstrators, so it's really a choice as to where you'd like to watch.
Yes, Your Honor, I'll watch them.
Thank you. No. Let's go ahead and present well. If you need to, go ahead.
Great, you get your.
Madam Timekeeper, ready?
Yes.
All right, very good.
May it please the court, ladies and gentlemen of the jury, opposing counsel, and your honor. Today's trial is a matter of mistaken improvement or incompetence. The plaintiff has accused Shooting Star Gun Club of being incompetent in hiring Drew Cantrell as a safety agent. However, all the evidence brought forward today was that Shooting Star's actions were nothing but justified, reasonable, and competent. The plaintiff has claimed Shooting Star's hiring and promotion of Drew Cantrell was negligent. Negligent hiring refers to the hiring of a person known to be a danger to others. Drew Cantrell, there is absolutely no evidence has been brought forward today to provide that Drew Cantrell fits this definition. Yes, Cantrell had previously violated minor safety rules regarding firearms. However, he was corrected on his behavior by Coleman, and the incidents were never repeated. Also, these were completely unrelated violations. And again, they were not repeated once Cantrell was corrected. The prosecution expert, Dr. Morgan Judd, even testified today that mistakes do not define an individual, and therefore should not be used to negate fitness to handle firearms. So let's go over Cantrell's qualifications. Drew Cantrell is an experienced firearm user who has been around firearms for their entire life. Before Skylar Coleman, head of Shooting Star Gun Club, hired Cantrell, she carried out a thorough interview and background check on Cantrell. More significantly, Cantrell is a certified holder of a firearm instructor certificate, which he received in November 2020. Now, ladies and gentlemen, let me remind you that Imperial law holds that in cases concerning negligence, juries must consider common practices within the industry concerned. Within the firearms industry, it is common practice that those who hold a firearm instructor certificate are qualified to lead firearm safety. Hence, the plaintiff's allegations that Cantrell was unsuited to lead the firearm safety class are utterly baseless and nonsensical. Now, let us discuss the nuances of the unfortunate incident that resulted in Justice Carbo's injury. When Carbo returned to Shooting Star Gun Club to receive the training course Coleman had offered them, she was first given a waiver draft. May I direct your attention to this document, which has been marked as Exhibit 7 for identification. This is the waiver that Carbo signed. This waiver states that the signer, in this case, Justice Carbo, acknowledges the risks involved with being in a firearm and holds Shooting Star not liable for any damages caused by the signer's own actions. And ladies and gentlemen, the evidence brought forward today proves that what happened to Carbo was, in fact, caused by her own actions. So, let's go over exactly what happened during training. After filling out the waiver, Coleman directed Carbo to Drew Cantrell, who took her to the firearm range along with another new firearm owner, Nick Allred. As Justice Carbo has testified today, Cantrell carried out proper, extremely thorough instruction in firearm safety during the class with Carbo and Allred. Cantrell demonstrated how to safely handle a firearm and follow firearm safety. Next came time for Cantrell to demonstrate how to fire a gun. And here is where the story has been split into two different accounts. The plaintiff's version of this story would have you believe that Drew Cantrell, who again has been around firearms for his entire life and is a certified firearm safety instructor, flinched from the unexpected recoil of the firearm. In the plaintiff's fantasy of this incident, this is what caused Cantrell's second shot to misfire and shoot Justice Carbo. However, Dr. Jackie Stowe has proved today that it's highly unlikely that the recoil would have caused someone so experienced as Cantrell to flinch so violently and redirect his aim so dramatically. So, ladies and gentlemen, let us put this fairy tale out of our mind and consider what truly happened on May 28th, 2022. Avery Lang was an eyewitness to the fact that Justice Carbo was crowding Cantrell while Cantrell was demonstrating how to fire the gun. Immediately after Cantrell fired the first shot, Carbo was observed by UN to have jumped and bumped into Cantrell. Nick Allred also noted that Carbo's left arm jerked into Cantrell's firearm. Carbo's sudden reckless movement caused Cantrell to drop the gun and unintentionally fire a second shot into Carbo's leg. As a matter of fact, Cantrell only intentionally pulled the trigger once during the training course. The second shot was fired as a direct result of Carbo's interference, causing the gun to drop. Overall, the evidence brought forward today undeniably proves that Cantrell is taking all proper safety measures throughout the firearm case. Ladies and gentlemen, it was Carbo's ill-timed reaction that directly led Cantrell's gun dropping and the shot misdirecting and hitting Carbo in the leg. Now, ladies and gentlemen, once again, this is a matter of mistaken improvement or incompetence. Shooting Star Gun Club has done nothing wrong this trial. Skylar Coleman hired and promoted an employee with proper qualifications to run the safety. All standard and proper procedures were carried out in both the sale of the gun to Justice Carbo and the promotion of Drew Cantrell, the firearm instructor. The accident on May 28th was not due to incompetence by Drew Cantrell or Shooting Star Gun. Rather, it was due to Justice Carbo's poor positioning and reactions, which caused her to jump and bump into Drew Cantrell while he was attempting to demonstrate how to safely fire a gun. Shooting Star Gun Club provided all necessary and proper safety measures in this gun training class by providing a certified firearm safety expert and a safe range environment. The plaintiff has failed to uphold the burden of preponderance of evidence they promised they would uphold. As the jury, it is now your duty to bring justice to this case and find Shooting Star Gun Club not liable. Thank you.
Thank you. And our timekeeper, please let us know how much time counsel for Carbo has for their rebuttal.
Your Honor, the plaintiff has 3 minutes and 26 seconds left.
Don't hurt you. You got it.
Yeah.
No, you're good. Just don't. All right, thank you. Hurry.
Your Honor, just to clarify, 3 minutes and 26 seconds for
3:26, Attorney Wu.
It's not.
Please.
Members of the jury, I want to start by talking about something that opposing counsel just said. It stuck out to me. They said that the May 28th accident was due to Justice Carbo's poor positioning. Poor positioning in stall mode. You heard today that that position, Drew Cantrell told them to stand in. How was Ms. Carbo supposed to know what position was safe? She had never done one of these training courses. That was Ms. Cantrell's responsibility. Mr. Cantrell didn't put them in a safe position. And that's because Ms. Coleman didn't stop them from unsafely handling firearms in front of customers. Opposing counsel also called Drew Cantrell's mistakes minor. You heard from Dr. Morgan Judd that if you know nothing about guns, if you know nothing about gun safety, you should know those 5 rules, those 5 industry standards. Members of the jury, violating those industry standards are not minor mistakes. They're major mistakes. Ones that should be a cause of. Finally, members of the jury, opposing counsel just stated that Drew Cantrell was an experienced firearms user. Now, experience doesn't make someone a competent employee. The plaintiff argues that it's because the reason why they were so experienced but still couldn't use guns safely is because no one stopped them. No one corrected them when they messed up. No one was there to hold them accountable when they made those mistakes. It doesn't matter how long they've been using firearms for. That doesn't make them a competent employee. Your Honor, this case, it's alarming that defense counsel is calling these violations understanding. They're calling it a part of human nature, something that we should accept on behalf of employees that are handling weapons in front of our citizens. That is alarming, members of the jury. For that reason, we ask that you find Shooting Star Gun Club live. Thank you.
Very much for your presentation today. My goodness, 2 days, 4 presentations, innumerable meetings, travel. Well done. The judges are going to take a few minutes to complete our ballots. If you need to stretch or use the bathroom, and can I suggest that you don't need to do either of those things? Feel free to do so, but come right back because we are going to, we've been reminded how little you care at this point, what we want to say. And so we're going to be very brief and then get you out to a much deserved meal and companionship with your colleagues. So everyone, try to just hang in there for just a moment. If you want to retreat exhibits, or do anything in the courtroom that you may do so.
Press. Did you hear it?
How are you?
Yes, I did. Thank you.
Good. For, can you video or
Oh, not, I've got video witnesses, sorry.
Oh, you're old.
can you, person's like in the back. You know, where we great.
Shake Shack?
Oh.
There's a Shake Shack, like, and then from here, they did go yesterday.
I got it.
Shake Shack?
Okay.
But I didn't go earlier, I'm gonna go back.
Awesome. Bye, Lena. Do you guys need the exhibits? We'll take those back. Yeah, of course, yeah. Are these, I'm not sure which ones are yours. Awesome. Thank you.
Thank you so much.
He really has.
Awesome. I'll check that. We're all
Okay,
set.
and just give us okay. Guys, if you get your seats,
We're all good, yeah.
we've been told that all the ballots are entered. Again, we understand the logistics here that you've been through 2 or 3 or 4 tense days. Remember how young we all were on Friday evening? And so at this point, we don't know where you're headed from here. So we understand that our comments should be as short as possible, and we can hang around for a couple of minutes, I guess, if you want anything further, but we would really question your sanity if you did. The jurors and judge come to this experience with different experiences, which I think is one of the real benefits of this competition. When you're being judged, I think it's not good to be judged just by people who are steeped in mock trial. It's not good to be judged just by people who've been attorneys for years. It's good to have a mixture of experiences, because that's what real attorneys deal with. A very smart attorney told me when I was struggling to first practice law, and I thought my opening argument was awesome, to Imagine I was giving it to 10 people or 12 people in line in front of me at Walmart, and would they get it? And if they wouldn't, then it wasn't any good. So I think this is a good experience. So with all of that, I'm going to ask each of our jurors to just give you a short understanding of what their background is coming to this, and then whatever comments they feel may be pertinent. Juror number 2, Mrs. Lamb.
Well, thank you. I enjoyed watching it. Let me give you a little bit about my background. I am a trial attorney and I also do appellate argument throughout the country. I am a senior partner at a law firm with 40 years of experience, probably 35 years of coaching or being involved with mock trial. So I'm very committed to the mock trial programs, not just because people are going to be lawyers, but it helps you find your voice and your power. And I think that's the first thing about this. This is a good experience for that. Keep on trying to work on that. Okay, two things for future things. One, if you've got a gun, don't be pointing it at people. It was being waved around. I'm sitting there going like, oh, don't shoot me. And that was on both teams. So if you ever have a gun case again, you've got to treat that gun respectfully if it's weird, if it's as if it's real. Otherwise, it might go off. Other thing, that this is for whatever in this situation, the fact finders, the deciders are the jury. And I think that the lawyers in particular, but all the people, you want to have that engagement with lawyers. Don't get too close. There was some talk with your coaches about where you should be positioned in the courtroom, the eye contact that you have. Sometimes if you're an attorney, you say, could you tell the jury, just turn your head a second before you go back? But for at least some people, I was wondering, were you told not to ever look at the jury? So that would be something I would think about. And then the last thing is just to bring your best self every time to the game. And I think you did, and I really appreciated it.
Thank you. Juror number 1.
Hello, everyone. I'm Ethan. I'm an undergraduate student at the University of Chicago. I'm on the mock trial team there. So coming at this from a little bit of a different perspective, I'll try to keep this incredibly brief because I've been in your shoes and I know that these comments literally mean nothing. You're just going to go eat dinner. But a few things. The first thing is, I've been in a lot of mock trial rounds. I'd say presiding Judge Lambert might be one of the best presiders I've ever seen. He's giving you a lot of clues on objections on what to say. And make sure you're listening to that. Like what we differentiate like super high level mock trial from that we can help you differentiate you against your opponent is being very responsive to what the judge is saying. There are a lot of hearsay objections where Judge Lambert would say it's being used for the truth of the matter asserted. He's cluing you in to say like the other purpose that it's being used for. For a character evidence objection, the difference between a procedural or a substantive character evidence objection, make sure you're listening to that and are clued in when you're making your arguments. He's giving you a lot of instructions on where to go. Just make sure you're attentive to that during the objection argument itself. The other very, very quick things I would say, I would really strongly echo the positioning point made by Juror Lambert that I was here before the round, and before the round with your team, you should standardize where you're going to direct and where you're going to cross from. So just have everyone go with their witness, put the witness on the witness stand, tell them to look at the jury and position yourself where you're going to all do your direct examinations. And then similarly, where you're all going to do your cross examinations. This can really help and will look like you've prepared before the trial. Just that sort of level of standardization. And the final note is I love themes, and I wish sort of I really liked the theme about only being a feet away or whatever. The like safety shouldn't come down to a few feet, but that needs to, if you're going to do it, you need to make sure that comes out in the closing and then in the directs as well. And the same thing about improvement and incompetence, it sort of got lost after the opening as well. So this goes equally to both teams, but just make sure if you're doing a good and fun theme that you do it throughout the entirety of the trial. But please go eat dinner after Honorable Judge Lambert's comments.
Well, you complimented me, so you're my favorite juror. Well, 11 years as a trial attorney, left my little partnership to teach high school mock trial, and have done that for 20 years and now retired. One, my sense is that the 6 of you sitting here, if you're in the lunchroom at your respective schools, are personality plus. You're interesting, you're persuasive. Some of you, when you crossed over to here, became much less so. So I would underline, highlight, emphasize the first point that Juror Lambert made, which is try to find a way to bring your personality, which is all different, into your presentations. You would be the same person you are in that lunchroom. Number two, please be careful of phrases that enter our word like viruses and come to mean different things. This is not a comment on any one particular team, but to give you a couple examples. Just to clarify, I came to understand that meant, I'm going to repeat my question. That's not a thing. You know, we're not clarifying anything. If you've got something on the person, leave them. Get it done. Engage the jury. We've already talked about that. I told you at the beginning that once I said to you, it's your witness, I didn't need you to ask me to proceed. And then virtually everybody said, may I proceed now? So listen to the judges. You don't have a jerk here who is presiding. But I've been in courtrooms. I was in a courtroom where the presiding judge, this is way before any of you were gleams in your parents' eyes, the presiding judge had a picture of his father. This is all absolutely true. A picture of his father on the bench. And the rule was communicated to us by bailiffs, do not touch the bench or the picture. And an attorney walked up and moved the picture during a break as a kind of joke. And the judge was a little bit wacky, closed the courtroom, put the bailiffs on the door, and told everybody they were staying in jail until someone told them who had moved his father's picture. Listen to the judge. If the judge says, I'd like everybody to be here, then be there. Please, I assume all of you are destined for glory in your respective states. Little things matter to people who sit here. So if one attorney is playing with a fidget or something in their hands, if somebody else has closed up all their books and everything when other things are going on in the courtroom, if there are people yawning or whatever it is, that's something that people look at. Please engage the jury. Final thing, dumb stuff is going to happen. Bad things are going to happen. They always do. They always do. Anyone who has tried cases, anyone who's tried mock trial cases, anyone who's tried real cases knows that no matter how much you prepared, no matter what you did, something bad happened and leaves you just staring. In that circumstance, you need to have an escape. You need to be able to walk to another place in the courtroom and turn and hit something else. You need to be able to pause presently and deliver additional content. You need to skip over the part you can't remember, you just got heard it, and go to the other one. A partner I had for many, many years prepared an expert witness. The short version is when they said blah, 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 he was to say yes. And there in the circuit court for Somerset County, in our little state, he said to him, blah, blah, blah. The witness said no. After weeks of preparation, at which point my colleague, my partner, turned to him and said, exactly. And in fact, no one knew the difference, right? And so when stuff happens on the stand, what did I hear you understand? And deal with it. Have a strategy for dealing with it. If your only strategy for dealing with this stuff is that it's never going to happen, then that's a strategy for failure. I did all that in 3 minutes and 44 seconds. You're gone. You're done for the day.
Also, a reminder, have your representatives pick up pizza from 2-1 immediately.
I wish you well this year. If you're ever in the area, you know, I'll look at it.
How can we help you? You need, in terms of breaking all this down.
I got it. Don't worry about it.
Seriously?
Yeah, 100%. I'll be quiet.
That fits with what I want to do.
Go get food. Go get food. I'll do. Don't worry about it. Yeah, you're all set. Thank you so much.
Okay. Thank you for your time, Tom.
Wait, seriously.
I'm good. Okay. Yeah.
So, you're ready to pick up right now. When does the closing ceremony start?
I believe this was a certain.
Okay. Is it
I
okay if we're not there, or?
I highly doubt it's going to start on all the.
It's obviously, okay, so maybe,
I would.
like, it's okay if we show up closer to 8? Or?
Probably. Yeah, you probably like. I would just eat right now and then
Try to run as quickly as possible. Very much. It was fair to say, yeah. So who's gonna get through? Can you get through it? You want to help? You want to go get through? You have to be there in 13 minutes. Pretty sure it's smart.
Yeah. Is this somebody? The courtroom.
Thank you so much.
You're welcome.
Thank you.
Remember, you're gone.
That was fun.
Duck. Thank you, Bailey.
Thank you so much, guys. Thank you.
All of you folks. Where are you all from? Where were they from? Toronto, do you have any? Oh, very good. All right. Well done. Safe travel.
I'd be very surprised if that was your last game.
That was our last slide.
No.
It could be tomorrow.
Now.
Simmer down. Yeah. Right now, they are bringing food up to 411. They expect you to food or whatever you need. Yeah, it's down to we want to get into the careful. Okay, so we're going to be eating in the lobby area of floor 11. And then floor 11, if we need to eat anything, we're going to get down at 48. Go back.
It's like.
Don't know.
Yeah, we can figure something out, right? Yeah, let's. I can't. Like actually, perhaps my least favorite company in the world. Like Lockheed Martin standing above. I'm not like I actually am looking all that because no, it's just like it's just a little bit. Yeah, go and put it in here. Just put it. Oh, should we put this? Where should we put this?
Yeah, so we are gonna put all Chromebooks in, you can just stack them right here for me. And then if you have a charger, oh, do you guys just have the Chromebooks?
Yeah, the chargers are, we're doing 2 traps. So our box was like taken from
Here. Okay, so if it looks like this,
Got it.
you're gonna put it in this bin.
Awesome.
If it looks different, set it right here.
Okay.
Thank you so much.
This stuff should we just throw?
Pens can go. Out there. Sorry, guys.
No, you're so good.
Okay. What else do you have in your hand? Put your plastic back things, put those in here. And then, yeah. Once you guys come back, just bring, and then evaluators, guys, just put them right here.
Okay.
Thank you. And then phones.
Oh, that's yours. Yeah.
Save your charger. You would bring it.
Oh, I also think.
Guns. Perfect. And then put that phone right up there.
Got it.
So we're gonna figure out.
Awesome. Thank you.
Thank you, guys. We really appreciate your help.
Yeah.
We can start with this. Yeah, we haven't really, we are, it's kind of just delegating spots. There should be some kind of smaller box to put on that. It's like, here, like this. We don't need, we have two
Or
pen
those
boxes. I think we have two pen boxes.
We do, it might be out there.
Yes.
Okay.
Just sit here. Here, yeah, let's do headphones and this. And with the iPhones, are we just turning them off, like shutting them off? This.
So
You want to
mention
shut the
phones.
iPhones off?
What's up?
Shut the iPhones off, like,
Please.
yes.
Matthew, can I ask you to do one of those things?
Yeah.
Like, people can still see this, yeah, so can we
Yes.
just move everything inside?
Absolutely, yep. First of all.
One presider is 3.
Hey.
Oh, well, we're just sorting.
You need something up or?
Okay, do you wanna hand right putting all the gowns and thing? Okay.
Where is space? How would you round up?
It was great. It was a good one. Jeremy presided and I actually.
No, great, that's so fun.
It was fun.
That's awesome.
Oh, okay.
Yeah, those judges.
These are mini. Wanna put. Gravel inside, except for the thing with Dolly, those are. These charges, separating them, but they're 2 different kinds. So there's the USB ones and there's these ones. So these are.
And then you guys can just put the gavel first, and then the gavel.
This is smaller.
Okay,
Okay.
this is also smaller.
Empire Fam teams are out of Buckingham, if you want to see the like boxes and supplies are there. But
Okay. Oh, so we can put them in there. Yeah, no, he doesn't want it.
Oh, I see. One thing.
Sorry,
Are you guys doing, are you guys just, are you just hanging out?
I think we're meeting our, we're meeting or.
Oh, okay. No worries.
We never. Here they are. Well, maybe.
Yeah. I think I am as well. These are different. So this is.
Yeah, have a good night. Thanks for your help.
These are the same.
Yeah.
I found these in the net support.
Okay, and then volume is like, still has everything.
Okay, so these are four of them.
Okay, how does this?
The same.
Okay, then maybe all the other ones are the same, and then
That one makes sense.
this one.
That's different.
Oh, yeah, okay, so they, then this can be the orange box, and then whatever's not orange. Oh, the other ones.
hey guys, I have swear notes. I'm missing one award. Can you check in the Buckingham room? It's in a black case. One award. I can still present it as.
Where did we go? Yeah. Like,
on good.
No. You also apologize to me. That's great. Because I'm pretty sure the 5 boxes that came from my rooms were just thrown together. And sorry, can I get past that? Yeah, I'm sorry. No worries. Doesn't need that box, so let's get in the way.
Yeah, let's do that. I love that stack of backup ballots we had. I just have no idea where that went. So, one for final round, you need one evaluator spread, one use of ordinance, one providing.
You texted Justin, that was your text on Justin's phone?
No.
We found it, or was
Yeah,
that?
we have it.
Was that, sorry,
That
who's,
was me.
oh.
No. If it isn't a lot, let me. I would not have made food any younger. Yeah, I feel like being a I didn't even boost for any rounds the first.
Good.
So today was kind of my first. So those are very good people. No, of course.
This is a problem that
So this was good rounds. Do you do more piano right now?
Like who's this says, but I'm just thinking something.
That is like really dangerous for the year. It's been out for a long time.
It's not anything.
Oh, I think it's definitely.
Yeah, he's not.
Fine, okay.
What's up?
You want the, does it want it?
What?
Already gave it.
Yeah, no, here he does.
In one of the, either of these two bins, these are both going to the championship. Both of these? Yeah, okay, so I did take it. Oh, sorry. Yeah, we need 5 chargers in each, and then we're doing, yeah. Okay, we'll figure that out once we sort her. These like these packets and drinks. No, not usually, but you know. Justin was saying.
Chicago shirts back here.
Saying?
Chicago.
It's all.
It's all just like trial stuff.
Yeah, it's all trial stuff.
Probably. Oh, cool. Oh.
Oh. Sarah, this is sorry.
Yes. Very. Brent said I can walk. Yeah. We'll probably do this with anyone. We've got living here.
Are you staying?
What?
When are you?
I'm here.
Also, clarification, I'm here till like Wednesday, and so
shit,
I'm
yeah.
planning, I'm planning on like doing all, like, so do as much as you can, but like, you guys should watch closing,
Do you
or at
not
least the
have
onwards.
a life?
No, I have meetings, well, I'm here for other reasons besides that hour.
Okay.
But I just mean I'm leaving Wednesday night, so I'll be here like all day Tuesday.
Yeah.
So I can help Justin with all of this, meaning like, you know,
I'm
because
definitely gonna try to do
your
as
brother, yeah, you want to see.
much- Yeah, I really do.
Where's your brother at?
He's for Trinity. So
Hey,
we'll do the defense attorneys. Like wanting to watch one of his files, but I missed it.
yeah, I took a nap. Took a nap. Good.
You did not
You
take
did
it.
not take that.
Okay. Good.
So we are opening every trial box and just separating everything into the boxes that they're coming out of. I did. You did it in your room?
That's
fine.
stressful.
Hey, everyone needs.
I'm glad.
I want to talk about core computers.
Val, did you feel sick at all last night or this morning?
Yeah, was it just me and Matthew?
It was,
It
I,
I did not. Oh wait, actually, Jacob, can you just give those back to me?
yeah, in your guys'
Did you
room,
guys cook the squid? You were
I
all
did.
fine.
in your guys' room last night, I got really quiet for the last like 10 minutes because I was focusing so hard on not throwing up. Like when James was
Oh my
asleep, I
god.
was like sitting in the chair and I was like, I'm probably
You
moving
were
muscle.
quiet.
Yeah.
I was wondering why.
I ate the smallest piece of squid ever.
So
I
it's
don't
not
think it was-
squid.
And then as soon as I got back,
Literally the smallest piece.
it wasn't
It's
anything.
a hot pot. Yes.
I don't know what it was, but yeah, I also got hit with a migraine and everything.
Meow.
I didn't have any nearly as bad as.
Let's-
We're doing 2 different Chromebooks, so
Oh, she's got a big one over here.
yeah, this is gonna be a little laptop box, and then maybe the blue box in there will also be a laptop box. And then these ones, yeah.
But not much of the.
Oh, so maybe it would be better to put. No.
Oh,
I think it was-
Chromebook not in there?
Oh, yeah.
Well,
the gray one.
the gray one.
Oh, just
The
separate.
gray outline.
Just
Okay.
the black ones are. You can, honestly, we can put the black ones on. Ones.
Justin just doesn't want it to be too heavy. He
Okay.
said. Heavy, because they're shipping.
So you want me to just grab all the flags and put them?
Yeah. Except don't touch this. Because this is champion.
What about
Here's the thing, I think we should probably start.
Let's do that. Except the
We'll
only.
find like 6 empty boxes, line them up and then. or
Well,
maybe
we're
just-
talking about for the final
Oh,
instead
for the
of throwing
championship.
things
Oh,
in there.
makes
For
sense.
double check.
How's it going?
There's already papers in there, but yeah. These are all the newer numbers.
What is in here?
Oh, there's hell. In that room, right?
Oh,
Okay, we have stickers.
Oh, okay, we can take all of that out because we're gonna bring that to the kids.
yeah, 'cause they just gotta go.
Yeah. Well, we could probably put some food in there and then we can use that for the other laptop.
That idea. Where, do you have, how much are putting the USB?
I haven't even encountered it.
That,
I heard you guys' Uber got canceled and you like several times.
you did, that is true. Oh, it's also true. I felt like the hot pot was overrated.
Wait, did you not have it last year?
What?
Did you not have it last year?
I did. I thought it was better last year for some reason.
So, my opinion is I like the vibes of hot pot more than the hot pot itself.
Yes.
Yeah.
That's the thing.
I will,
Yes. I'm
like,
not complaining, I had a vibe.
no, it was fun. Korean barbecue is where it's at.
In terms of taste. And,
Yeah.
Yeah.
I found, have you guys ever been to a Korean barbecue at karaoke place? Did you not, did you go to a karaoke bar when you were in Korea?
No.
Did you even go to Korea?
I did karaoke every night in Vietnam.
Oh my gosh, that is like the best place. The vibes are so good. You like rent out a private room.
I did get a lot of people.
Oh, what?
Oh,
Oh, yeah. Perfect.
Nice.
Yeah.
I definitely, one of these phone chargers is definitely fine. I sacrificed one of my own.
So you should probably speak.
Yeah, I just don't know. Mine is like specific, so I think I should see it. If you see anything that's like looks more Apple-ish or like that, or like Apple log or something.
You want the,
It doesn't matter. I have multiple. It's fine.
You know, take the best one, Matthew.
you honestly deserve it. Like, you don't want this for
Yeah.
anymore.
I just mean,
Yeah, this is like.
that. Oh, no, yeah. Tiny for no reason. Okay, I'm bucks.
let me pull this down and then it can be almost empty. Are we doing a, do we have a gun box yet?
Oh, yeah, yeah, it's.
Yes.